Hi guys, welcome back. Welcome back. We have part two. They're back in the courtroom. I knew as soon as I left the live feed, of course, they would go back live into the courtroom. But like I promised, I am back. Welcome to Take It to Trial, where we will be the judge. Definitely share your thoughts and your opinion in regards to what you think of the trial so far, guilty or not guilty. I'm your host, Sweet Pea Diamond, and once again, welcome. I am going to go ahead and take us back into the courtroom right now, so we don't have to wait. We waited long enough, right? Exactly.
In this particular case, Judge, if it was Robert Creed, as the defense is suggesting, would have had to get out of Ronny Walker's car while he's driving and commit the murder outside of his car. At that point, Ronny Walker should have and could have driven away and fled from that scene, but he did not. He waited until the defendant got back into the car and then started the car and not just fled, then he turned off his lights in order to assist and aid in the getting away, clearly showing, circumstantially at least, Judge, that Ronny Walker had an intent that this crime be committed or be successfully accomplished. Okay, there is no way they've sufficiently established that she was shot.
Hold on, I missed something. Go back to the beginning of that argument. That who got out of the car and shot?
According to the defense, if you want to believe the defense, right, it had to have been Robert Creed because they were the only two people in the car. So if Robert Creed got out of that car and shot, Ronny Walker then waited for him to get back in the car.
There's no evidence of that.
Yes, there is, Judge, because the shots, she was shot outside the car. For sure she was killed outside.
There is no evidence that Creed shot. Yeah.
But that's
if they were the only two people there,
but that's what they're arguing.
You just go beyond your argument and say, there was a third person there waiting to kill her, and they just delivered her there.
Judge,
you can say anything you want, but there's no evidence that Creed shot anybody.
I'm saying this to rebut their argument, Judge. If they make that argument that Creed did it,
what they say is not evidence.
I understand, but then we should be able to argue two alternative theories, as the court is well aware, which is that if
you have to have evidence to convict someone, not argument.
Judge, we do. Circumstantially, we have proven that Ronny Walker was the driver of the vehicle.
You think you prove that Ronny Walker? You're trying to prove now circumstantially that Creed was the shooter?
No. I'm not proving that Creed was the shooter. I'm saying that even if Creed was the shooter, Ronny Walker assisted, aided, and abetted him in committing this crime.
There's no proof of that.
Judge, he drove to this location. The only person who drove to that location was Ronny Walker.
Yes.
So he knew that something bad was going to happen, because why would you take a young 14-year-old girl to a vacant field in a dead lot unless you know that that person's going to be killed?
Are you alleging under the principal theory? I'm going to let you finish. But I just want to make sure that I'm thinking along the same line as you. Are you saying that for the principal theory to be correct, that Creed shot the girl and Ronny Walker's their principal to that?
I'm saying if that's going to be their argument, we should be allowed to rebut that and say.
I'm not asking you if that's their argument. Are you saying that Creed shot the girl? If you're going to argue the principal theory to the jury, then you have to believe that Ronny Walker is not the shooter and Creed is the shooter. Yes or no?
Judge, no, we can argue two alternative theories.
I'm not saying you can't argue two,
but
to argue that one, you have to say Creed was the shooter. Yes or no?
I can say yes. Ladies and gentlemen, if you believe Creed was the shooter, guess what? Ronny Walker was just as involved.
Show me the evidence that Creed was the shooter. And don't say it's because there were only two people there, because that's not evidence.
Judge, do you understand that we have to be able to rebut their defense? Their defense is there's only two people in the vehicle, so their defense is going to be that Robert Creed was the shooter. We should be allowed, as the state of Florida, to argue that even if you believe that, and the state is not arguing that that's the case, right, but even if you believe that, even if crazily you believe that Robert Creed got out of that car and did that shooting, Ronny Walker was at the very minimum an assistant, aider, and abettor in committing this murder, which means he is a principal.
In what capacity?
As the driver, Judge, as the person who took this victim
to what crime?
To murder.
By who?
By either.
Show me the evidence that either, i.e. Creed, did anything regarding the murder. Except
I don't have to show you that evidence. We as a state have a right to argue alternative theories.
You have to show the jury the evidence.
They're going to argue that evidence, Judge. They're going to argue
that Robert Creed, evidence.
They're going to argue that Robert Creed had her had her phone number
I
in his
know what they're
phone.
going to argue. It's obvious.
So we should have the ability to rebut that and argue under the
You
circumstances.
can't
It
argue
does-
facts. that
Judge,
aren't
the
evidence.
only reason Ronny Walker was initially charged in this case was under the principal theory. To take that away from the state, you're basically taking this whole case away, because
Your
now
whole case, since jury selection till today, has been that guy over there, the last name of Walker, shot and killed this girl. That's been your entire case. Not one time have you put on any evidence that Creed was the shooter. Never. Until
Judge,
now.
we don't have to. We're not supposed to
You
put on
do
evidence.
have to. You have to prove your case beyond and to the exclusion of every reasonable doubt
Correct.
based on the evidence.
Correct.
And I haven't seen a single piece of evidence that says Creed's the shooter.
It doesn't matter, Judge, but they make that argument. We can argue that he
for
was
the
a
record, it doesn't matter.
he
that
was
the
a
state has provided no evidence of Creed's kill.
All right, if I can just finish putting my
Yeah.
stuff on the record. I'm also going to cite 675 Southern 2nd 196 TSV State. Again, while it is settled that mere presence at the scene, knowledge of the crime, and flight are insufficient to justify a conviction, it is also clear that elements of assistance of the perpetrator in intent may be proved by a combination of surrounding circumstances. We are arguing that there are these surrounding circumstances, Judge. We also provided Lewis v. State, which I know the court has already cited, so we would also rely on that. And Judge, it is the state's position that while we do not believe Creed was the shooter in any manner, if the defense is going to argue that, we should be allowed to rebut that and argue that even if the jury were to believe that, even if the jury were to say, well, we're not convinced Ronny Walker did the shooting, we can still be convinced that Ronny Walker assisted in the murder by taking her to this remote location and then driving the shooter away to assist him in escaping. All of that, Judge, should be allowed and should be admissible, Judge. And we are strongly believe that this case is a principal theory case if it's not the actual shooter, and we should be allowed to argue either scenario to the jury.
Okay. Well, in Turner, one of the guns was found underneath the driver's seat, which is where Turner was seated, giving him basically actual possession of a firearm. Let me read on here. So that's a distinguishing factor. I've seen no evidence presented by the state. If they want to make an argument, and I'm going to instruct the jury that I've already instructed the jury what the attorney says is not evidence, that should not be considered as evidence. They can argue whatever they want.
We should be allowed, Judge, to argue that even if you believe their theory of the facts, it still puts Ronny Walker as a principal to this crime. Even if you believe the defense's theory, which we are not in any way agreeing or advocating or believing in, because as Your Honor has said, there is no evidence that Robert Creed shot and killed her. However, there is evidence that at least Ronny Walker, even if he wasn't the actual shooter, did aid and assist the shooter in committing this murder. And that is what the state's sole position is. We believe we should have the right to argue each theory in this case. And there's enough circumstantial evidence to at least take it, if you look at it in the light most favorable to the state, there's at least enough evidence to present to the jury and let them make that decision. And he did not implicate Robert Creed. Judge, all of this is clear evidence that he was assisting and aiding Robert Creed if they believe what the defense says, which is that Robert Creed was the shooter. And we should be allowed that alternative theory of argument. I promise you, Judge, we are going to be arguing strongly that Ronny Walker shot and killed this woman. But when their defense gets up there and they start saying, it was Robert Creed, it was Robert Creed, he's the one who had the connection, he's the one who had the connection, then we should be allowed to get up there and say, you know what, maybe even if it was, what did Ronny Walker do? He drove this 14-year-old girl in the middle of the night to a remote, abandoned location. And then if Robert Creed got out of that car and shot that girl, he then assisted Robert Creed in getting away from the scene. All together. That together, Judge, is a principle all the way.
Do you think that's a real possibility that happened?
I don't think it doesn't matter, Judge.
Well,
If that's what they argue, we should be allowed to rebut that. That's all we're saying. It's not like we're arguing that that's what happened. We're arguing the opposite. However, if they get up there and blame Robert Creed, we should have the right and ability to rebut that under the principle theory and say, even if you believe with no evidence whatsoever that Robert Creed shot her, Ronny Walker aided and assisted him in committing this murder by driving that girl to that location, by then driving Robert Creed away with the lights off, mind you, clear attempt to help him escape from the commission of this crime. All of that, Judge, combined together is a principal theory.
Why doesn't that make him an accessory after the fact then?
Judge, because we're arguing circumstantial evidence in the light most favorable to the state.
What's your circumstantial evidence?
The picking up this girl, that was Ronny Walker who picked her up.
Okay.
The driving her to this remote location, turning
I'm
off
just
the
gonna
lights.
object because it's being said over and over. It is not a remote.
Well, I want to hear it again.
I get it. It's not a remote location. It's a neighborhood.
It's a remote location in the court's opinion. It's at the end of a dead-end street in a vacant lot. That's a remote location. And it's just, there's no jury here.
I understand.
I can-
It's
I
just
can- and I know what
been
he's
said over
talking
and
about.
over again, and it's not true.
Well, Judge, I'm saying this because we can't get into the intent. We don't
You know,
what his
you know what this
mind
reminds
was.
me of? And I'm not trying to be cute. Travis Tritt wrote a song called A Modern Day Bonnie and Clyde. If you've ever seen the music video, Billy Bob Thornton picks up a girl at a gas station. She gets in the car, they go off, they stop to get some food on the way. Next thing you know, she's running out of the gas station with a gun in her hand and some guys trying to stop her. And he takes off. He didn't know what she was going to do.
Does he take off with her?
He took off with her, but he didn't know she was going to rob the gas station. So later on, now he likes the idea that they got a bunch of stolen money and cigarettes. So they pull over to count the money and smoke the cigarettes, and the police arrest him. He's an accessory after the fact because he had no prior knowledge that she was going to intend to rob the store. There has to be some evidence that Creed knew that there was going to be a murder at the end of that street.
The principal
I mean,
theory-
Walker had to know
principal
that.
theory, Judge. I
And that
believe-
had to be, how does Creed know what Walker's thinking?
And I believe, Judge, in the light most favorable to the state, and that is what Your Honor is supposed to be doing at this moment in time when it comes
Yes.
to judgment of acquittal, okay? In the light most favorable to the state has proven that a number of things. Number one, Ronny Walker was the driver. Number two, that he drove to this location, okay? There's no reason to take this 14-year-old to this location unless you plan on doing something bad to her, okay? Number three, he then drives the person, if it wasn't him, which we're arguing it was, but if it was Robert Creed, he then drove that person away to protect him with the lights off, mind you, so that they
No
cannot
question
pick him up.
about that.
All of that is assisting, aiding, and abetting. That's what we're talking about. So even if maybe, like, if we want to go off on a crazy tangent and say that Robert Creed did this all on his own, got out of the car and shot her, he still stayed there and helped him escape. Not just successor after the fact, Judge. He had to have witnessed it.
Oh my gosh, I had to pause there. They are really arguing hard in regards to the possibility of a acquittal. Oh my goodness. I know this judge is not leaning towards not sending this to the jury. Oh gosh. We'll see. Okay, I'm gonna keep it going and see if the prosecution can get this argument off. And okay, and this is before we get to the defense portion of this case. So here we go. Sorry. Just had to take a breath there.
Then provided him an avenue to get away, which means he was involved and assisted, aided, and abetted this crime.
I
This is all the
don't
light
have
most
any
favorable.
problem with all that.
Okay.
I'm good there.
This is then he lies to police. He doesn't give the name of Quincy Creed as being involved with him or even there. All of this stuff, Judge, all combined together, we can argue satisfies that intent under the circumstantial evidence theory. We're not arguing that we have a direct statement by him written down where he says, I'm going to go with Robert Creed and kill this girl. But the fact that they were acting, the way they acted together in concert is circumstantial evidence, Judge. That, taken in light most favorable to the state, should allow it to go to a jury question and a jury decision as to whether or not he was a principal in this case, if they want to think or believe that the defense's argument that Robert Creed was the shooter. Judge, it's a safe position that we have sufficient, substantial, circumstantial evidence to at least present that to the jury and let them make the decision as to whether or not that applies. And we are relying on the Turner case, the TS case, the Lewis case, the McGuire v. State case, all of these cases, Judge.
Yeah, I read all of those and I found a lot of distinguishing factors in those.
Judge, we can always find distinguishing factors. The fact of the matter is when you look at the case in the light most
Well,
favorable
I
to
think
the
the Turner
state.
case is your best argument at this point. But let me go. All right, I'm going to take 5 minutes to go read something real quick. Yeah, well, yeah, go ahead and let the defense respond, so I can take that back with me.
Judge, just as the court pointed out, there was some evidence, be it minimal, but there was some evidence in the case that Turner was in possession of the weapon. And so, again, that is distinguishable from the case that we have here. The state has not introduced any evidence that if it were Robert Creed, okay, that shot and killed Nilexia Alexander, no evidence that Mr. Walker knew what was going to happen. Sure, even if he thought something bad was going to happen, like they were going to go buy drugs and give this 14-year-old girl drugs, or even if he thought something bad was going to happen, like Creed was going to go off into this isolated area and have sex with a 14-year-old girl. Neither of those things are first-degree premeditated murder. The state would have the burden of showing at least some evidence that Mr. Walker was aware that either first-degree premeditated murder, second-degree murder, or manslaughter was about to happen. That is it. And they have not introduced any of those evidence, any of that evidence.
Any response to that?
Judge, only that the evidence must be looked at in the light most favorable to the state. And the fact that this grown man is picking up a 14-year-old girl, driving her to this location at 3 a.m. in the morning indicates all you need to know that they were planning on doing something to this girl.
There's no doubt.
Okay, so if they were working, then he was involved in getting that girl to that location and then helping. If you want to believe, and again, Judge, we are not going to argue that Robert Creed was a shooter in any manner. But then he helped him get away. The shooter was outside that vehicle. The shooter was not within the vehicle, at least not on the shots that killed her. Those shots all took place outside that vehicle, which means that if Ronny Walker was in the car and Robert Creed did all this on his own, he had to know what Robert Creed was doing at that time and then proceeded to help him drive away. So he was now at that point, whether he had the premeditated intent at the very moment, he certainly had it by that point in time. If you look at the evidence in the light most favorable to the state, Judge, which is what we're asking this court to do, we cannot get into his mind. There is no, he doesn't have a diary where he wrote out, this is today I'm going to go kill Nilexia Alexander. But when you look at the circumstances surrounding her death, all things point to that Ronny Walker knew and was involved in what happened to that girl.
The driving away part, that's quite frankly, it's not even a consideration because that's after the fact, right?
Right, I
Clearly,
understand.
someone's
We got to
sitting
get to
there.
that point.
Right, exactly. And I said the court that case law about the difference between the accessory after the fact and the principal.
Right.
So the driving away part does not impugn any knowledge as to what was going to happen beforehand. Certainly, maybe if they wanted to charge Mr. Walker with accessory after the fact, then maybe we would have a different argument or a different conversation, but that's not what he's been charged with. The driving away should not be a relevant factor.
I disagree with that immensely, Judge. The driving the perpetrator, if it was Robert Creed, as they're suggesting, clearly shows he had an intent that this happened, that this crime occurred. And just getting to that location, Judge, we can at least argue circumstantially, this is his car. He drives and picks up that girl, and then he drives that girl to that
I understand your
location. I don't understand how that cannot be a principle. That's circumstantial evidence that looked at in the light most favorable to the state, and I get it. And the defense can get up here and argue to the jury day long that, hey, he maybe didn't know what was going to happen. But then I should be able to rebut that and say, listen, even if he knew, because that shooting took place right outside his car, and he clearly intended to help the person, whoever it was, commit this crime by helping him get away. Plus, he also took this woman to this location, this girl.
Judge, none of these are new arguments. The court has already ruled.
I'm trying to make it clear, Judge.
I'm going to go look at this again.
These are all the circumstantial evidence that put together in the light most favorable to the state should clearly at least allow the
I
jury to
understand.
consider.
We'll be in recess for 5 minutes.
Okay, guys. Oh, the prosecution is arguing how hard for this to happen, and it looks like the judge had already ruled on it, and he's going to take 5 minutes. And I hope that is only 5 minutes, right? Let me see. We have a little bit of time. Let me see if I can get us back into the courtroom because the feed. I got a couple minutes. Let me see where we're at. I hope we can move past the 5 minutes, if it's 5 minutes. And remember, the jury is not in here at this point in time. and we're getting close to the defense case. But the way they argue, is there going to be a defense case? Let's see. So it doesn't look like they came back yet, and I didn't fast forwarded all the way through. So we're live. We're looking at the sign of Florida, the state of Florida. Anybody have any thoughts on this argument? I would love to know your thoughts. Like, I've never seen like where they had to argue this part, and it's because the defense has most likely to ask for a motion for acquittal. And a judge doesn't think that the state has put enough evidence up to present certain things to the jury, which is concerning. So hopefully we'll be back and we don't have to look at the sign too often, but definitely let me know what your thoughts are in the meantime, considering we don't have any TiVo time here, because I went right back in as soon as they went right back in. So we wouldn't miss a minute of it. And I guess my 5 minutes is different from the court's 5 minutes. He must have to think a lot longer for his 5 minutes, right? But hopefully soon. I'm going to be hanging out. We are hanging out. And I thank you all for coming back and joining me and watching this trial with me. I'm an advocate, trial watcher. I love watching trials. I love seeing what evidence is presented, how they determine. Although, you know, outside of the jury, like we have additional information that the jury may not see. Like they were unable to bring in their prior bad acts because Ronny Walker was released for committing murder, attempted murder. Now, how he was released, I am not sure, but that just brings into play. Now we have a life lost again by the hands, allegedly. Let me say allegedly, by the hands of Ronny Walker again. So, I mean, this is really concerning. You know, I do believe in the rehabilitation process, but up under certain circumstances, let me say that. So, because we all want productive members of society, but we don't want people that's harmful or hurtful in our society, that's causing more harm than good. Yeah, Benny. I tell you. I don't know why the judge is not getting it. I definitely hope this 5-minute break that he is taking helps him get it. I would definitely be shocked at it if it doesn't go to a jury, but we'll definitely see when the judge returns where we're at with this. Until then, I guess we're looking at the 13th Judicial Circuit's emblem or sign. But yeah, it worries me that the prosecution is having to put up so much of a fight for this evidence or this determination to be made. Typically in most trials, when the defense, when it's their turn, they're like, hey, we move for acquittal. And the judge like immediately says, no, I disagree. They'll go to the jury, denied, acquittal denied, but not in this case. In this case, he's actually considering it. And the state has to actually prove this stuff to him. So it kind of, I don't know. It raises my little antennas and worries me, but we'll see what they decided. I did see some head movement. So hopefully we about to get right back in there. And we'll just see what happens here. Mm-mm. Like so concerned. Yeah, and in other news, like I did not finish watching the other case that we kind of peeked in on in regards to the Monica Simontelli's sentencing. I'll look at that a little bit later, but I'm pretty sure she's going to jail for the rest of her life. Considering all the salacious and all the grimy and all the extra stuff that her and Robert Baker, her lover, did. So that's an update on that. I think in regards to, I don't know if any of you guys are watching the Diddy trial, but that's currently about to be getting ready to be handed over to the defense. The prosecution that actually presented their last witness today. And the defense will be putting on their case. I heard the defense's case is probably about 4 to 5 days long with the witnesses they have available. So it may be in the jurors' hands for the Diddy case, which is another big high-profile case, by the end of the week. So if any of you guys are interested in that, I'll definitely provide some updates in regards to where they're at with the Diddy case and some recaps on the channel. So make sure you check it out. Daily recaps, only because you have to kind of wait for all the tweets and stuff to come in because it's in federal court. So unfortunately, they don't allow us to have cameras in there. You know, Benny, I think I actually did. I seen that trial. I think I know exactly what you're talking about. Yeah, that was very sad. They were. Is this the one where they were laying in the bed together, the brother and the sister, and the father ended up shooting them after getting into the argument with the mom? I think this was recently, like within the last 7 months, that trial happened. Let me know. Okay, yeah. Very, very. Oh, that was a sad one. And I think they even questioned the little boy, you know, even though he was a little bit older now, but oh yeah, I definitely yep. I seen it. I was like, you know, it's not too many cases that, you know, that ever that unique, but yeah, that was very, very, very sad. Yeah. Yeah, I don't know if this is a new judge or not, actually. This is the first time that I've been in his courtroom, and it's so funny because typically in Florida, like it'd be the same judges that had the high profile or the cases that are actually being televised or streamed. But yeah, definitely. Yeah, that was definitely a sad case. I guess we'll find out sooner than later. I probably can look up some information. He's like, we need that judge. Hopefully, this judge makes the right decision. That's what we're gonna keep our fingers crossed for, right? This judge is gonna make the right decision. We're gonna keep our fingers crossed, and hopefully, this goes, you know, where it needs to go to make, you know, where it's not just one person determining it. It's a panel of his peers that are going to determine whether or not he's guilty or not, and if the prosecution has determined it. But I kind of understand from a judge point of view that they can only allow so much evidence, because the worst thing that a judge wants to have is something to go up for appeal, right? Like they do not like that. So they want to definitely go out of rules, and in order to make sure that nothing that they do or any objections that they sustain or any motions that they deny have a standing on appeal. So we'll see. His 5-minute research, I definitely see is taking much longer than what we thought. Like, I want to hear what is going on. Yeah, absolutely. Absolutely, Benny. Yep, absolutely. And it's so crazy because like the entire time today, they have not had the jury in there. I don't know if the jury is in the back or are they just waiting in a little room for them to get rid of this stuff? But I tell you, if I was a juror, I would be upset. Like, y'all call me when y'all finish. So I hope they don't have them in the back. But like, call me when y'all done and we'll come in or start trial later and I'll come in then. But I do not want to be just sitting back here in a little room waiting. Has anybody ever in the chat been on jury duty? Myself, no. I've never been on a juror panel. Not because I didn't want to. I think when I was requested to go on a juror panel, I was actually on bed rest, so I couldn't go in. But I know I got selected like twice, and each time, unfortunately, they just called me at times where I was not able to go in. But I think that as a person in the community, that that's I would love to do it, right? I would love to go on a juror, be selected. I don't know if they would select me or not, because I probably got my own opinions about a whole bunch of stuff, and they'd be like, strike, no, she can't do it. But I wouldn't mind serving on a panel, to kind of see the evidence, and be able to make certain decisions. And then I think about it sometimes, and I'm like, no. I really don't want to have to hold that burden. Maybe like a traffic case. If they call me in for a traffic case and I get selected for that, well, yeah, you were going 65 and a 40. You're guilty. But I don't know in regards to like when we talk about life and death decisions in regards to people, like if I would want to hold that burden. Let me see if we have anything. I see head movement. Okay, it looks like we're back in, guys. Here we go. I'm gonna mute up. Me muting up. He better get his microphone on.
Considering the request for judgment of acquittal, I'm now going to reverse my decision to grant the JOA on the principal factor. And these are the reasons. The overriding filter that I'm looking through is that it's in the light most favorable to the state. The driving of the car, the lights being turned out, the car being positioned so that the passenger side or the driver's side where the victim was allegedly seated, facing that side. The fact that the shots occurred within seconds of the car being on the scene. And Creed's testimony, which is completely contradictory to the physical evidence about a shot being fired inside the car. There was no round found inside the car. There were no bullet holes found inside the car. Everybody said the windows were up. But where's the round? It wasn't in the girl. And it's more consistent with that shot being done outside than it is inside. In fact, it's more consistent that there were no shots fired inside because no round was located in the car. And there was no, even if the round had been taken out of the car, it would have damaged the inside of the car, and they went over that car. So those are the things that I find favor the state in the light most favorable to the state. So I'm going to allow the principal theory and deny the judgment of acquittal. Having said that, I would ask the defense if you would like an extra instruction that if you find him guilty of premeditated first-degree murder, did you find him guilty of principal or not? Or something to those words on the verdict form.
And Judge, I think that's contained within the firearm finding because I think.
Well, I want it separate. I want to know if they found him guilty under the principal theory or not. If so if they, for instance, I have a case pending before me now, I have to send somebody on where they found the person guilty of first degree murder. They found his co-defendant not guilty, but they found that he possessed no firearm, shot no firearm, killed no one with a firearm. So now I have to wrestle with that one. So I want to make sure in this case, regarding what interrogatories they check off, I want to find out if they, and that's only if the defense wants that on the verdict form. And you,
I mean, to be clear, it's not a cure.
Not cure.
We're not waiving an
I understand
objection of
that. No, I wouldn't, I don't know, I'm not asking you to do something that would cure or acquiesce.
We could add the interrogative that is added sometimes for juveniles asking, did the defendant actually kill Nilexia Alexander?
Or did you believe it was a principal? We'll present one to you
Okay,
and we'll see, we can always tweak it.
okay.
All right,
Judge, are you going to provide it then?
we'll provide that.
Okay.
Yes. Anything else?
Will you be adding the principal instruction back into the instruction?
Yes, I am inviting it. and
Judge,
putting
I'm
it
going
back.
to walk up. I've got the principal instruction as well as the mere presence.
He's
I've
got
got the
that.
principal instruction as well as the mere presence. The one we sent you didn't.
She
have
asked for
that.
the mere presence after that, right?
She did, Judge. And so
Okay.
we're, that contains both those two instructions that were litigated over. So that can be added to the packet.
What, any particular place in this packet you wanted added? After murder, second degree, or in between premeditated and second degree? Or, thank you. Say
Yeah,
again?
after 3.3D. Just before plea of not guilty and reasonable doubt. I know that it won't, under our instructions, it's kind of weird to put it there, but just kind of basically between page 6 and page 7, just when after you get to possession of a firearm and discharge causing great death, then
Telling you, this cameraman is having all types of issues today. Let's see where
I'm
he
gonna
end
call
up.
my secretary and have her now print out new copies and adding that in that
Could you
area.
do that? Because I don't have the
Yes.
new ones that we agreed to. Well, you know what? I think they did come in while I was in there.
She emailed them.
I just haven't printed them yet.
Yeah, they're all emailed, but I can.
Yeah, I got them. We can print those.
I can have her add the principal in your presence right after 3.3D.
All right, do that. But I'd rather have an extra copy than not enough.
But yeah, let me contact her, and then she'll email that to you. That's okay with the court.
That's fine.
And, hey, listen, so we need you to put the principal in your presence, the one you took out. We need you to put them back in. And can you put them in after 3.3D, but before 3.7, please? Yeah. Yeah, okay, if you go to page 7, 3.3D, right after that is a space before it starts pleading not guilty at 3.7. You can put the principal theory or principal instruction and the mere presence right after the principal instruction. And then it should go plead not guilty. And then if you can send a copy to the judge so that he has a copy of the board's review. Okay, great, thank you. All right, Judge, that's being done.
All right, thank you. Did you want to wait for those to get printed before we begin?
It's up to you. I
I'm-
think
I'm-
we're fine.
I'm
Start.
ready to get
We all
going.
have the case law, so
All right,
Now we can get started, Judge.
ready for closings?
Defense is ready.
All right, so I'm gonna bring them in. You're gonna close for the
Yeah.
jury.
Well, I already rested in front of them.
I mean, yeah, but I mean, rest for the jury. Oh, you did in
I
front of
already, we brought them in.
Oh, yeah,
before
okay. I
lunch,
kind of lost track of that one.
Yeah.
And then we can start running the close.
So the only concern
So we about to go into closing statement, guys. Oh gosh, here we go. So this is going to probably go to the jury today. I'm assuming that they'll maybe do jury instructions today. Okay, let's tune in.
that I have, Your Honor, is that I don't have the most updated verdict form with the special finding.
We're working on it right now. We can just stick that in.
Thank you.
Just real quickly, did y'all notice that the defense was like, no, we ready. Like, we don't need a break. We don't need anything. Whoa. Yeah, Alicia, yeah, 4 days. 4 days. This is day 4. Wow. And that seems like very, very quick for a death penalty case. Like, I would not want anybody deciding my life in 4 days, but you know, if you're guilty, you decided somebody else's life, right? But yeah, this case is definitely quick.
Here's the question I'm gonna ask y'all, the defense.
Yes, sir.
Did the defendant actually and personally kill Nilexia Alexander?
Right. Yeah. that's
Define
it.
actually and personally, to make sure that there's no.
Sure.
State, go right at.
I'm sorry, Judge, how I said,
Did the defendant guilty of murder in the first degree as charged, and the defendant actually and personally killed Nilexia Alexander as one of the interrogatories? All right, that's what it'll be. Bring the jury in.
the findings after guilty, correct? Judge?
Yes.
I'll add that to all.
Okay. Megan?
Right. I'm glad that we listened to
All right.
okay, guys. I know they brought to bring the jury in, but I'm so glad that we, you know, even though we had that the feed has stopped earlier, I'm glad during that period of time we were actually able to listen to the opening statements. So in the first stream, remember, we got the opening statements that we recapped today while we were waiting, and now we are into the closing arguments. Like, yeah, here we go.
For the jurors.
Yeah, Alicia. Yeah, I hope I'm pronouncing your name right. If not, I apologize. Yeah, he was in jail before, and that's very concerning to me. Like, how did he get out for murder before, and now another life has been lost, and a younger life has been lost due to him being back on the street. So you're absolutely correct.
Jury's back on, may be seated. Thank you, ladies and gentlemen. Be able to follow the court's instructions again. No media, we didn't look anything up. No one spoke to you, didn't speak to anyone about this case. Very good, thank you, folks. You're gonna give me the closing argument, State?
Thank you.
Judge. Sorry.
Ladies and gentlemen, the state of the defense has now rested their cases. For the record, the state of the defense has now rested their cases, and they are about to begin their closing arguments. Remember what the attorney says is not evidence, but you should listen closely to their arguments and rely on your own recollections of the facts and evidence during the case.
Thank you. May it please the court? Counsel? Members of the jury. On June the 6th of 2022, Nilexia Alexander was a runaway. She ran away from home. She made some bad decisions. She was out and about at 2:52 a.m. And you have the video footage. She's out there casually. She's on her phone. The defendant, Ronny Walker, comes right by, drives around. Nilexia Alexander gets into the defendant's vehicle at 2:52 to 2:53 a.m. And that is the last time that we ever see Nilexia Alexander alive. Why? Because on June the 6th of 2022, the defendant purposed in his heart that he was going to find Nilexia Alexander. He was going to drive around to find that girl, pick her up, drive her to a remote location, and kill her. Which means, members of the jury, that he had to get his car ready, that he had to make sure that he had a gun, that he had to have chosen the location. And members of the jury, he even chose his passenger. You know, gullible Robert Creed, sick Robert Creed, can't read Robert Creed, childhood friend Robert Creed. That's the person he chose to be with him, members of the jury. He picked her up at 2:52. And by 3:08, Nilexia Alexander was dead, shot in the head multiple times and left to die in a remote parking lot. That's exactly what happened. The vehicle belonged to the defendant. The blood in the car, mixture. Nilexia Alexander and Ronny Walker. The phone that is tracking with Nilexia Alexander's phone, the defendant's wifey. Remember the document where we showed you the download from the defendant's new phone? How does he refer to Erica's suite? Wifey. He had his wifey's phone, that 305 number, and it tracked from his house, which was, by the way, only less than a mile away from Nilexia Alexander, picked up Nilexia Alexander, drove to the location, and these two phones, Nilexia Alexander's phone and Ronny Walker's girlfriend's phone, are tracking at the exact same time, all the way to the crime scene, all the way back. Everywhere the defendant went, that's where Nilexia Alexander's phone was going. And you know what, members of the jury? The next day, later on that day at about 3:20 p.m., the defendant drives to Tampa General Hospital. Obviously, he doesn't know that Nilexia Alexander's phone is still in his vehicle. And that's why the police went to Tampa General Hospital. That's why they had that lead. Well, members of the jury, Nilexia Alexander made some bad choices. She was 14 years old, and it has been said at about 1 a.m. in the morning, just casually walking around, there are only two categories of people: victim, prey, and predator.
Objection and proper argument.
On May the 6th of 2022, Nilexia Alexander was prey. Because members of the jury, you'll learn that if you don't know which one you are, you're prey. Nilexia Alexander was prey. She was picked up, she was taken to a remote location, and she was murdered. And she was murdered by Ronny Walker. That's what the evidence shows. And every single piece of evidence corroborates that fact. The phone evidence that puts the defendant at the location prior to the murder, during the murder, after the murder. Nilexia Alexander's phone tracking with the defendant's vehicle, and the DNA in the defendant's vehicle. That cannot be stepped on. That cannot be ignored because, members of the jury, this DNA of Nilexia Alexander's is a mixture of the defendant and Nilexia Alexander, and it's in the rear, the back seat behind the driver. So this is where you come in. Throughout the case, you get to listen to this case, right? You will learn from the jury instructions. Judge Fichon is going to read it to you. You are the sole determiners of a witness's credibility. You get to decide what to believe and what not to believe. You can listen to a particular person's testimony. You can disregard everything that witness says or some of what the witness says. That's the type of power that you have. So members of the jury, think about the common sense. The defendant's DNA is mixed with Nilexia Alexander's DNA in the back seat area of the vehicle. So you have to ask yourself, how often does one sit in their own vehicle in the back seat behind the driver? How often does one do that? To the point that their DNA will be mixed with the victim? Do you know what this evidence shows? It shows that the person who shot Nilexia Alexander had personal contact with her.
Objection, improper statement of the facts.
Which
I'll just remind you what the attorney said is not evidence.
which is supported by the evidence in this case, members of the jury. Personal contact with the victim. The victim is in the defendant's car. The defendant's DNA is mixed with Nilexia Alexander's DNA in the backseat of the defendant's car, a car that is registered to Nilexia Alexander. This girl is shot, and somehow she's shot at least one time in that vehicle, or close enough that there's DNA and blood evidence in this vehicle. This vehicle is right there when Nilexia is either dragged or pulled or somehow is now in the field, where the defendant, Ronny Walker, gets up close and within 12 inches of her face shoots her again and again and again. Yes, members of the jury, that's what the evidence shows. Contact. Yes, that is why the defendant's DNA is mixed up with Nilexia Alexander's DNA. That's the evidence. Now, the state has told you from the beginning that we have the burden of proof. Members of the jury, we accept that burden. We told you we would meet this burden, that we would prove this case to you beyond and to the exclusion of every reasonable doubt. And that is exactly what we have done. You will get the jury instructions, and then you will learn that it's not so much that the state has to prove every little point. Did you swab the casing? Did you dust that particular shell casing? Did you follow up on every social media situation or possibility? That's not what the state has to prove. The state has to prove the elements beyond and to the exclusion of every reasonable doubt. So let us talk about the elements. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. Nilexia Alexander is dead. The death was caused by the criminal act of Ronny Walker. There was a premeditated killing of Nilexia Alexander. And then we talked about an act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. So let's talk about the witnesses. Remember, Robert Creed said that that the defendant woke him, says, "Hey, let's go drive." Robert Creed said, "I wasn't feeling well, but I got into the car with him." He's like, "Let's drive around, look for this girl." They drove around. Nilexia Alexander, you see her on the video. You will have the video footage from the location she was picked up on. Because you'll remember that the vehicle is facing, and the Nilexia Alexander gets into the vehicle on the driver's side. Okay, that's going to be important because whoever she's having contact with would have been on the driver's side, which means she trusts the driver enough to get into the vehicle, right? And then it just happens to be that when you go back to look at the video from 3000 North Highland, her body is on the driver's side of that field. She would have had to come out still seated behind the driver's seat. So Nilexia Alexander is dead. That's not in dispute. The death was caused by the criminal act of Ronny Walker. Ronny Walker picked her up. Ronny Walker drove her to a remote location. Ronny Walker turned off his lights. Ronny Walker made sure that she shot multiple times. Ronny Walker drove away, leaving Nilexia Alexander in that field, abandoned and alone. Ronny Walker drives away with his lights off. Ronny Walker drives around a bit and then goes to the Thornton. Ronny Walker cleans out his car. If people who even liked Ronny Walker and were, I mean, you saw them, you get to judge their credibility. If they were somewhat distant, hostile towards the state, but they still testified to the facts of what the defendant did. Remember the individual from Giant Motors, right? The person who the defendant worked with, right? You ask him, yeah, did you tell the police about, the defendant cleaning the car for a long time? Yeah, but he would have cleaned the car. Well, on the day of, he talked about how the defendant cleaned up that car so much that it was odd. So much so that Tampa Police Department went back and collected the vacuum cleaners and everything to see if they would find evidence, right? The defendant cleaned up his car, but the car is still filthy. You have the photographs. Why is the car still filthy? He's not cleaning it up for cleanliness or to declutter it or for organization. He's cleaning it to try to get rid of the blood. And he believed he had gotten rid of the blood. And that's why that jail call that we played becomes relevant, members of the jury, because in that jail call, and you'll have the jail calls, he says, if they give me 5 years, I'm going to jump on it. I'm going to take it. They have DNA in my car. That's why that jail call becomes relevant. And then the other jail call, where he's trying to convince Erica Sweet, his girlfriend, to be a witness for him. I don't know what I did. I was hoping you'd be a witness for me. And then she gets mad, so listen to that jail call again, right? Because it's her phone in play. Because he had lost his phone or broken his phone 2 weeks prior to this. And why is that relevant? Because nobody is taking the position that Ronny Walker is not intelligent. That's not the state's position. After all, think about it. He chose Robert Creed. He used Robert Creed to call Nilexia Alexander. Robert Creed is staying with him, and for the 2-week period in time in which Ronny Walker doesn't have his phone, that's when his phone, Robert Creed's phone, is calling Nilexia Alexander. And then we ask Robert Creed, do you think it's odd that your phone is calling Nilexia Alexander? Yes, I think it's odd. I do think it's odd. Well, why didn't you say that this individual had access to your phone? You didn't ask me. So I didn't say. Simple. This is not an insult to Robert Creed. It's that he's simple. He cannot read. He cannot write. He's semi-homeless. This is his childhood friend. And never would he have thought that his friend would put him in this situation. And yet here he is, right? He's in that car. Defendant is using his phone right up until, in that 2-week period. And then what happens, right? What happens? He shoots Nilexia Alexander right there in front of Robert Creed and then turns to him and says, "You better not say anything because I will kill you." And then you have Robert Creed, homeless, no car, no driver's license. Where is he going to go? Where is he going to go that his childhood friend cannot find him? This is not about someone else's view of their life. It is Robert Creed's viewpoint. He knows that this guy knows him well. And for that reason, Robert Creed lied for Ronny Walker. And because he lied, he is facing 30 years in prison. That's the fact. He lied in a capital offense, and now he's charged with accessory after the fact. Now, members of the jury, this is not going to be about whether you like the way the investigation was done, whether you like the witnesses in this case, because it's not about that. The witnesses we have, they came from the defendant, right? We have Erica Sweet because that was his girlfriend, right? That's why we have her. That's why we had to call her. Were you using your phone? Were you in that car? Were you driving around on May the 6th? Did you have a passcode on your phone? She says, yes. Who had access to that passcode? Ronny Walker. Were you living with Robert Creed? Did you give him access? No. The person who had access to my phone, according to Erica Sweet, is herself and her boyfriend, and she was wifey, right? Remember that? Wifey. Those are the two people who had access to that phone. And that phone is tracking from her home to the crime scene where Nilexia Alexander's body is found, to Thornton's, ultimately back to Erica Sweet's home. That's how the phone tracks. So who are the witnesses we have? We have Erica Sweet, and while she cares about Ronny Walker, she still says the only other person who would have had full access to that phone is Ronny Walker. But then we ask her, hey, have you been speaking to Ronny Walker since the duration of this case? She says no. And that's why those jail logs become relevant, because they are communicating constantly from 2022 all the way to 2025. There is a connection between these two people, and that's the hostility or the pushback that you would have probably seen as you watched her testify. But still, she said that the person who had access to her phone was Ronny Walker. So if Robert Creed was even using that 305 number, then who would have given access? Ronny Walker. And why would he give access to Robert Creed? Why? Because you have to be discerning, You're the sole determiners of a witness's credibility. You get to judge this evidence. You get to judge the witnesses. You get to understand and seek the processes and understand what was happening that day. Because you also hear from David White, and when the defendant is confronted on May the 13th of 2022, when law enforcement come in contact with him and say, your car was used in a murder, they ask you, who is it that you are with at Tampa General Hospital, right, at about 3:20 p.m. on May the 6th? And who does he say? Day, David White. He doesn't say Robert Creed. He says David White. Why is he lying? Why would he say that? We know it was Robert Creed. Okay. When the defendant is asked, what is your girlfriend's name? He doesn't say Erica Sweet. He says Erica Hudson. He doesn't know Erica Hudson is going to just wander by, show up at Giant Motors, talk to law enforcement. He didn't see that coming. So before she showed up, he gave a name of Erica Hudson. And that's why I asked Erica, did you ever go by the name Erica Hudson? She said never. Why did the defendant choose to lie about that? Why did the defendant say he was with David White when he was with Robert Creed? Why? Why did the defendant tell Robert Creed that he would kill him if he tells on him? Consciousness of guilt. Why did the defendant say in his jail call that he would take 5 years? Consciousness of guilt. Why is that important? Who takes 5 years for the murder of a 14-year-old? Who does that? Except you're guilty. So those are the elements that the state has proven beyond and to the exclusion of every reasonable doubt. You will get the lessers, which is murder in the second degree and manslaughter. But as it pertains to count 2, there's a tampering with physical evidence, and here are the elements. To prove the crime of tampering with physical evidence, the state must prove the following 2 elements beyond a reasonable doubt. Ronny Walker knew that a criminal trial, proceeding, or investigation by a duly constituted prosecuting authority, law enforcement agency, grand jury, or legislative committee was pending or was about to be instituted, and Ronny Walker destroyed, concealed, or removed any record, document, or other item with the purpose to impair his ability in such proceedings or investigations. If you find the defendant guilty of tampering, you must further determine whether the state has proven beyond a reasonable doubt that the tampering related to the criminal trial, proceedings, or investigation related to a capital felony. The court instructs you that murder in the first degree is a capital felony. So why is this relevant? Because you heard from Stanley Wilson, remember? He said that he was, so we concede Stanley Wilson is a multiple-time convicted felon, and his felonies pertain to insurance fraud and acting as a bondsman, and it's too...
Objection. That's not evidence of a proper argument.
To that end, the defendant made contact with Stanley Wilson and talked to him about his case, right? And during that conversation, the defendant, of course, says, you know, it's Robert Creed that committed the crime. Then he says, actually, let me just tell the truth. I, Ronny Walker, I'm the one who committed the crime. And Stanley Wilson's like, why? He believed that Nilexia Alexander had given him an STD. Why is that relevant? Because you don't have to like Stanley Wilson. You don't have to like any of the witnesses in this case. But what you must do is be discerning. It just happens to be that there was no evidence whatsoever that Stanley Wilson and Robert Creed knew each other or had any contact. And yet Robert Creed said to you that the defendant turned to Nilexia and says, are you having sex? She says no, and he shoots her. And then he continues to shoot her, right? And then you have Stanley Wilson, yet another person, separate apart. And he says that the defendant said that Nilexia Alexander had given him an STD. But Stanley Wilson told you more than that Erica Sweet and Nilexia Alexander knew each other. There was conflict between them, okay? This explains Erica Sweet's casual attitude about this homicide. The fact that the police had to get her an investigative subpoena just to talk to them about this case. This explains why Erica Sweet is continuing to communicate with Ronny Walker from 2022 all the way to 2025. This explains a lot. But you have to ask yourself, why is the motive sex or a sexual related act when Wilson talks about it and when Robert Creed talks about it, these two people who do not know each other? It is there that you judge the credibility of the evidence. It is there that you look at the credibility of this evidence. Because, members of the jury, today, here and now, this is not that place where you judge the victim. This is not the place where you say, I remember what I was like, or where anybody gets to say that they remember what they were like when they were 14. That's not what this is about. This is about what the evidence showed. And the evidence shows, whether it's from Stanley Wilson or Robert Creed, that the motive for this murder is that the defendant, Ronny Walker, is having some kind of sexual act or having performed some kind of sexual act with Nilexia Alexander, and it's to that reason that he believes that he might have gotten an STD from her, and it's based on that and the conflict with Erica Sweet that he decided to kill her. Coincidence? He would have to be the unluckiest man in the world for Stanley Wilson and Robert Creed to both have the same murder, having no connection with one another in this case. Now, members of the jury, you will get this instruction on the principal theory. And it reads, if the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did, if the state proved beyond a reasonable doubt, one, that the defendant intended the crime to occur, and the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. To be a principal, the defendant does not have to be present when the crime is committed or attempted. For the first degree premeditated murder or second degree premeditated murder or manslaughter, the state must prove the defendant intended that the killing of Nilexia Alexander occurred. It is not necessary for a principal to know every detail of how the first degree premeditated murder or second degree murder or manslaughter will be committed, as long as the principal intended the first degree premeditated murder or second degree or manslaughter to occur and did some act or said something that was intended to help and did help the first degree premeditated murder or second degree murder or manslaughter occur. To be found guilty of premeditated murder or second degree or manslaughter with a firearm as a principal, it is not necessary for the state to prove a defendant knew another participant of the first degree murder or second degree murder or manslaughter or was armed. Why is this instruction important? Because, members of the jury, if in fact you do happen to believe that Robert Creed, who had no car, got into the car with the defendant, directed the defendant to drive to this location, got out of the passenger side, killed Nilexia Alexander, got back into the vehicle, his blood is not at all mixed with Nilexia Alexander, and he's never the driver, then the defendant is still guilty of premeditated first-degree murder, right? Because that would mean that the defendant provided the vehicle, right? Drove around, picked up Nilexia Alexander, 14 years old, at 2:52 a.m., drove her to a remote location at a dead-end street, made a U-turn, turned around, waited for Robert Creed to get out of the vehicle, walk around the vehicle, shoot Nilexia Alexander at least once in the car or close enough to the car to leave DNA, dragged her out, further out into the field, shot her again at least 4 times, right, total, then walked casually around to the front passenger seat, got back into the vehicle where the defendant would have had to wait as the driver, right, and then turn his lights off during this incident, and then drive off and then turn his lights on, right? That would mean that he assisted and helped the murder to occur. And let's not forget the cleaning of the car, because the only person that we have any evidence of cleaning the car is the defendant. And the fingerprint on the car cleaner and carpet cleaner is not Robert Creed's, It's the defendant's. And the place where people are saying he's cleaning the car is not where Robert Creed lived or worked. It's where the defendant worked, at the Giant Motors, right? And the phone that belonged to Nilexia Alexander is still tracking in the defendant's vehicle later on in the day at about 3:20 p.m. on May the 6th. So who got rid of the phone? Who had access to Nilexia Alexander's phone? Whose car was it? It wasn't Robert Creed. He didn't even have a driver's license. Which would mean that after the fact, the defendant would have gotten rid of Nilexia Alexander's phone. And why? Why are there only 4 casings in this case when we have 6 shots? Remember, members of the jury, you heard from the firearms expert. All the casings were shot from one gun, which would mean that someone got rid of 2 casings. Someone got rid of the firearm. Someone got rid of Nilexia's phone. Who? None other than Ronny Walker. Every piece of evidence points to only one man. Even where it might be argued that it looks like it could be Robert Creed, even then it still points to the defendant because of the time frame. So let's consider this. Here are the records, Robert Creed's number to Nilexia Alexander. This is from April the 29th through May the 1st. That's when that phone activity would have been, which would have been roughly around the same 2-week time period in which the defendant told the police that he did not have a phone. Then we have the defendant's new phone, right? May the 11th of 2022. Welcome to Boost Mobile. That's the defendant's new phone number that he gave to the police on May the 13th, right? He now has a new phone and it's after the date of the murder. Why is this phone record important? Because here's wifey, right? 305-910-9779, right? This is the person he's communicating with. That's that same number that is relevant to this case. Then you have Robert Creed. He doesn't have a driver's license. It's been revoked since 2009. And the address we have for him is in St. Petersburg. And if you can recall, it's in Pinellas County that he was ultimately arrested. Or the police went and interviewed him. Then we have these records, right? These are the phone logs. You'll have an opportunity to study them better. But why is this important? Because here we are, April the 15th of 2025. This is phone records from the jail system. This is Erica Sweet's phone number. And we have pages and pages and pages of the defendant and Erica Sweet communicating. And look, July the 8th of 2022. These phone records go all the way back to that time frame. Contact information from the defendant's new phone that he got on May the 11th. Here's wifey. From the defendant's new phone, State Exhibit 30B5. Where did we get the name Day from? It's from the defendant's phone. Why is this name important? Because when the defendant was asked who he was with on May the 6th of 2022, later on in the day, he said Day. And that's David White. And while David White wasn't happy to be here, he still says, hey, that person in the Thornton video, going into the store, that's Ronny Walker. Was I with him? I've never even been in Ronny Walker's vehicle. It's not that Ronny Walker would have mixed it up. It's that he's saying he's never even been in Ronny Walker's vehicle. And that's relevant because that's a childhood friend of Ronny Walker and Robert Creed. And he, David White, looked at the picture of Robert Creed and said, yeah, that's Robert Creed. And yes, that's Ronny Walker going into Thornton's. More evidence. Here you have the defendant's vehicle. There's his name, and there's the vehicle. Right down to the license number that you'll see. Why is this important? Erica Sweet. She lived at 18th and 26th. Where was Nilexia picked up? Less than a mile away from this location. Members of the jury, every piece of evidence. Look at this. Ronny Walker has an open wound. Look at that. State Exhibit F6. That's why there's DNA mixed with Nilexia Alexander. Side of the road that she's, when you look at the 3000 North Highland video, you'll see that the car's turned around. This is the side of the vehicle that would have been on the driver's side, members of the jury. It's another piece of evidence, all pointing to Ronny Walker. C-22. It just so happens to be that the defendant has a carpet and mat cleaner in his vehicle, and that's the item that we got his print off of. That's where you heard Thomas Gonzalez say that the print came back from this item. Not Robert Creed, Ronny Walker. Now, C-27, right here, you see this? This is where Nilexia's blood is mixed with the defendant's DNA. Why is this significant? How often does one even sit in the back seat of their vehicle, let alone DNA of the owner of the vehicle being mixed with Nilexia Alexander? This is a critical piece of evidence. Distance from where Nilexia was standing or in the area shortly before she was picked up, and Erica Sweet's home, 0.1 mile. The defendant walking into Thornton's at about 3:30, shortly after the murder. Remember, he got out of the driver's seat. And what is significant about the difference? Ronny Walker, he's dressed up in a winter jacket, a black winter jacket, members of the jury. On May the 6th of 2022, before he even started driving around to look for Nilexia Alexander, he's wearing a black winter jacket with a hat on. And in contrast, There's Robert Creed. State Exhibit 34. And here's the defendant's print on that cleaning product that we spoke of. Here's Nilexia. You can see the stippling on her face. The shots to her back area and shoulder right there. Shot to her head. And then the close shot. This would have been 12 inches barrel to skin. This is premeditated first degree murder. And this is a better view so that you can see the soot and the stippling. Now, members of the jury, you'll have an opportunity to listen to the redacted post-Miranda statement in this case, and that's where the defendant acknowledges that he didn't have a phone 2 weeks before. You'll get to listen to the defendant's 911 jail call where he talks about his willingness, and he kind of laughs about how he would take 5 years. They found DNA in his car. You'll get an opportunity to really take the time and look through all the video footage and see that the defendant's car is tracking exactly in the same direction as the victim's car in this particular case. You'll also have an opportunity to listen to the way the shots are fired. You will then note that there's one shot, pause, 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 time, then more shots. The shots alone is evidence of premeditation. The drive to that location, premeditated first-degree murder. The defendant turning off his lights, premeditated first-degree murder. The defendant citing someone else being in his vehicle, knowing full well it wasn't him, premeditated first-degree murder. The fact that Nilexia Alexander was in the vehicle with the defendant and her phone, and that phone has never been found, evidence of premeditated first-degree murder. The fact that he got rid of the firearm, that's evidence. Members of the jury, you will have an opportunity. You'll get a verdict form that looks somewhat similar to this. And it will say, we the jury find as follows: as to count 1, check only one letter as to this count A, B, C, or D, and answer all the associated questions under the letters section. A, the defendant is guilty of murder in the first degree as charged. It is the state's position that this has been proven beyond and to the exclusion of every reasonable doubt. Did the defendant personally carry, use, threaten, or attempt to use a firearm? Yes, he did, members of the jury. Yes, he did. Yes, he did. And did he actually possess the firearm? Yes. Did he discharge the firearm? Yes. Did the discharge cause the death of Nilexia Alexander? Yes. Did the defendant personally commit the murder in the second degree and manslaughter? Yes. They are lesser included offenses. But remember, the law requires you to come back with the highest offense proven. So the only correct verdict based on the evidence in this case is guilty as charged. Guilty of murder in the first degree, A, and He did possess the vehicle, the firearm. He did discharge it, and he did cause the death of Nilexia Alexander. And then moving on to count 2. We, the jury, find as follows as to count 2. The defendant is guilty of tampering with physical evidence as charged. And that should be your answer. The tampering was related to a criminal trial proceeding or investigation of a capital felony. Yes, it was. When all is said and done, members of the jury, there is absolutely no evidence whatsoever that you have heard from the stands from the witnesses that would support the notion that anyone else committed this offense. All the evidence that you have gotten points to only one person, and that is Ronny Walker. And what the attorneys say is not evidence, it's argument. You will have to go back and you will have to think back at what all the witnesses said. And then you'll see Robert Creed says that the defendant shot Nilexia Alexander. Stanley Wilson said the defendant, Ronny Walker, shot Nilexia Alexander. The evidence shows that Erica Sweet and Nilexia Alexander didn't get along. The phone record showing that Erica Sweet is communicating with Ronny Walker from July of 2022 all the way to 2025 supports Stanley Wilson's position that Nilexia Alexander had gotten into some kind of conflict with Erica Sweet over sex or a sex act. The fact that these two men, who there's no evidence to support that they knew each other, Stanley Wilson and Robert Creed, both cite some kind of sex attachment to this motive is evidence of the motive, the premeditation here. The fact that Robert Creed says, let's go look for that girl, and then Ronny Walker drives her to that location and shoots her multiple times and drives back. Every piece of evidence points to only one man. Members of the jury, Ronny Walker, he's guilty. He's guilty of premeditated first-degree murder. He picked up Nilexia with the purpose of killing her. He took her to a remote location and he killed her. And then he tampered with physical evidence. He is guilty of premeditated first-degree murder and tampering with physical evidence. And members of the jury, your verdict should say so. Thank you.
So definitely drop in the chat what you think in regards to the closing arguments that were presented from the prosecution. The defense is now about to present, and we'll see how they're going to attempt to try to poke some loopholes in the prosecution case and create some reasonable doubt. Okay, guys.
May it please the court. Counsel. Good afternoon, members of the jury. Proof beyond and to the exclusion of every single reasonable doubt. That is the burden that the state of Florida took on when they filed charges against Mr. Walker. The burden to prove to you beyond a reasonable doubt that he shot and killed Nilexia Alexander, that he is responsible for her death. When we started this case last week, maybe even the week before, who can remember, you all promised that you would hold the state to that burden. You all promised, and when you were sworn in as jurors, you promised the court that you would presume Mr. Walker to be innocent, not guilty. That presumption, even at this moment, has not left him. Now, I'm going to take some time and go over some of the evidence and some of the law that I expect the judge will instruct you on. And when I'm done, the prosecution, Ms. Fawcett or Mr. Terry, will have the chance to come back up here and talk to you again. But this will be my last opportunity to talk to you. I ask that every step of the way, whether I'm talking, Mr. Terry is talking, Ms. Fawcett is talking, you think critically about everything that you have seen and heard in this case. I'd like to start by talking to you a little bit about instruction 3.9, weighing the evidence. This is an instruction, again, that the judge will give you. You'll have a written copy, so you don't have to take notes of anything I'm putting up here. But there's something important that the judge is going to instruct you on. He's going to tell you whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and the quality of the evidence presented. They can come in here and present 1,000,000 exhibits. They can come in here and call 1,000,001 witnesses. But at the end of the day, the answer is still not guilty unless that evidence is supported and credible, and you are convinced beyond a reasonable doubt that they have met their burden of proof. The nature and quality of their evidence comes down to Robert Creed and Stanley Wilson. And now I'm going to talk about them in detail in just a few minutes, but let's take them out of a picture for a quick minute. Because members of the jury, if you go back to that deliberation room and you ask yourself, let's put Robert Creed and Stanley Wilson aside. What evidence is there that Ronny Walker is guilty of first-degree premeditated murder? None. Because what you are left with, if you take Robert Creed and Stanley Wilson out of the picture, you're left with the black car, okay? You're left with Mr. Walker in the car, but you also have Mr. Creed in the car, right? That you can't just discount the fact that every step of the way where you're seeing Mr. Walker or you're seeing Nilexia Alexander's phone, you're also seeing Mr. Creed. So you've got two people at the gas station shortly after the shooting occurs. You've got the DNA, and I'm going to spend a few minutes to talk to you about that. And I know sometimes these testimony of these witnesses can get a bit dense, but I hope you were paying attention. Because if you were, you will know what the witness testified to, the DNA expert, is not what Ms. Fawcett is claiming before you. Because again, remember what I say, what she says, that's not evidence. The DNA comes down to this. First of all, there are 3 people in this mixture that Ms. Fawcett kept bringing up over and over. 3 people. She conveniently left out the third person. Now, is that third person Robert Creed? We don't know. The DNA expert said that she cannot tell you that it is or is not him. She can't include him or exclude him. Could be someone completely different. So keep that in mind, right? That there's not just a DNA mixture between 2 people being Ronny Walker and Nilexia Alexander. There's that third person. But even more importantly, the DNA witness told you that a mixture does not mean physical contact. It does not mean 2 people left behind their DNA at the same time. She cannot tell you when or even how DNA is left behind. The witness even testified she cannot tell you if there's that presumptive blood that was left behind, that if that blood belongs to Nilexia Alexander. Ms. Fawcett brought up the open wound could belong to Ronny Walker. But again, there is no evidence, there's no way to know how far apart that DNA got there. So when we talk about a mixture, rely upon what the expert witness told you. And what the expert witness told you is that it does not mean that the DNA is happening at the same time. So in Ms. Fawcett's scenario where she has Mr. Walker cleaning the car, for example, perhaps maybe he's cleaning the car and that's where his DNA gets on there. He's wiping down the doors. He's wiping down drying it with a towel, whatever scenario, right? There are an unmatched number of scenarios as to how two different people's DNA can get onto a location at completely different times. So the DNA, although it is important for you to consider, is not as powerful as the state would have you believe for all of those reasons that I just discussed. So we have the DNA that was left behind. We don't know how it was left behind. We don't know when it was left behind. We have this black car. What else do we have without Robert Creed and without Stanley Wilson? We have the jail calls. Let me talk about that for a moment, okay? I encourage you to go back and listen to those jail calls, especially that one where Mr. Walker is talking about taking a plea deal of 5 years, talking about DNA. What you're going to find is that the way that that call was chopped up, it's not the same conversation. And the judge read you the instruction on the recording being edited. What you're going to find is that it's two different conversations happening, right? And think about it. Mr. Walker is facing the death penalty. The state of Florida is trying to kill him because they believe the state of Florida is seeking the death penalty because they believe that he in fact killed Nilexia Alexander. He knows he's not going to be offered 5 years in prison.
Objection.
Sustained.
He knows that the state is seeking the death penalty. Consciousness of guilt? Really? Does he realistically think he's going to be offered 5 years when the state's seeking execution? No. When you look at the date of the call, when Detective Whelan testified about the date of the call, you'll find out that that call was made the beginning of this year, January 2025. 5 years is what? Almost a time served sentence for him. So yeah, he would jump on that to not face the death penalty. Does that mean that he's guilty of killing Nilexia Alexander? Absolutely not. When talking about the DNA, again, you'll listen to it. It cuts off very quickly. He's just saying he got papers that says they found DNA in the car. That's all he says. He doesn't say anything to the effect of, oh man, they got me. They got the DNA. Or, oh man, I thought I cleaned the car better. How did I leave behind the DNA? That's not what's going on. So again, I encourage you to listen to that jail call. The jail call with Erica Sweet. Go ahead, listen to that one. Because what you're going to hear is that Ronny Walker is trying to convince Erica Sweet to cooperate and to testify. Now, you're not going to hear him trying to tell her what to testify to. You're not hearing him tell her anything like, hey, make sure that you don't show up to court. That would be consciousness of guilt. That would be tampering with a witness. But he's not doing that. He's saying her, you got to show up. I need you to show up. I need you to testify. He knew what she was going to testify to. And it wasn't the defense that called her as a witness. It was the state. The prosecution called her as a witness. It's not as though she did Ronny Walker any huge favors by coming in here saying that she left her phone behind in the car, that he had access to the phone, right? So none of those things equate to guilt, okay? So we've got the car, we've got the jail calls, we've got the DNA, we've got his statements to Detective Whelan. Again, nothing there. He was not as though he gives a confession to Detective Whelan, okay? The state wants to harp on this statement that Detective Whelan claims Ronny Walker made about the fact that he didn't have a working phone for 2 weeks and he broke his phone and all of that. And I'll talk about that some more when we talk about Detective Whelan's investigation. But again, none of those things are proof beyond a reasonable doubt. So Why am I talking about all of this? In order to find Mr. Walker guilty, you would have to believe Stanley Wilson and or Robert Creed. There's no other way around it. There's no other proof that Mr. Walker is at all responsible for the death of Nilexia Alexander. .7, plea of not guilty, reasonable doubt, and burden of proof. I'm going to talk about this instruction a couple of different times, but want to draw your attention to the portion that's highlighted, which says, a reasonable doubt as to the guilt of Mr. Walker may arise from the evidence, the conflicts in the evidence, or the lack of evidence. And I wanted to bring that up because I'm about to go through some of that with you. I'm about to go through the evidence, the conflicts in the evidence, and the lack of evidence, especially as it pertains to when we talk about Stanley Wilson and Robert Creed. .9, weighing the evidence. This is an instruction, and I'm going to go through these in more detail, and they'll be bigger. You'll be able to see them on the screen, but I wanted you to see the instruction.
I know. Okay.
There are not every paragraph is going to apply to every witness, but when we talk about Robert Creed and Stanley Wilson, these are some of the ones that specifically are going to apply to them. Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and the other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in the courtroom? Has the witness been convicted of a felony or a misdemeanor involving dishonesty or false statement? And then there's this rather large paragraph that I'm going to go through with you. I'm going to blow up the text in just a second that we talked a little bit about, I believe, in jury selection. And it specifically tells you, you must consider the testimony of some witnesses, and again, we're talking about Robert Creed and Stanley Wilson, with more caution than others. For example, a witness who claims to have helped the defendant commit a crime or who hopes to gain more favorable treatment in his own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his testimony with more caution than the testimony of other witnesses. However, if you find the testimony of such witnesses convince you beyond a reasonable doubt of the defendant's guilt or other evidence in the case does, then you should find the defendant not guilty. Or I'm sorry, you should find the defendant guilty. So let's talk about Robert Creed and go through some of those factors as it pertains to his testimony. Did the witness seem to have an accurate memory? The interesting thing about Robert Creed is that it appeared as though during his testimony that he had a more accurate memory here in this courtroom 3 or so years later than he did when he spoke with Detective Wheeland, when he spoke with Mr. Terry, when he spoke with me, all on prior occasions, right? Because his testimony is that now he's suddenly recalling facts that he never previously gave to anybody. Facts like the fact that he specifically recalls staying at Ronny Walker and Erica Sweet's home between April 29th and May 1st. He specifically recalls that here today. That's information he'd never previously given to anybody. And he was asked that question. He was asked by Detective Whelan. You heard Detective Whelan said, yes, he had a conversation with Mr. Creed about where do you stay? Mr. Creed told him, I stay with my brother or I stay over in St. Pete with my girlfriend. Never before mentioned that he stayed with Ronny Walker. That was some new information that he suddenly remembered here today. Or I'm sorry, here this week. Was the witness honest and straightforward in answering the attorney's questions? You are all the trier of fact. The witness's demeanor on the witness stand and their attitude and testimony towards the attorneys, that is all something for you to consider. That's a determination that you can make on your own. Did the witness have some interest in how the case should be decided? Well, certainly Mr. Creed has a lifetime of interest, right? Because if it's not him that shoots and kills Nilexia Alexander, or I'm sorry, if it's not Ronny Walker, then it must be him, right? That's essentially the conversation that he had with Detective Whelan. So yes, Mr. Creed has every interest in having this case decided with a guilty verdict. Does the witness's testimony agree with other testimony and other evidence in the case? And so there's quite a bit to unpack here. So I'm going to start with the communication on his phone between him and Nilexia Alexander. Okay. And Mr. Creed is sort of all over the map when it comes to this. Okay. Because up until this week in this courtroom, when you all heard it, he has always said, oh, that's my cousin. My cousin knew her, right? His cousin somehow, in the greatest coincidence of the world, knew 14-year-old Nilexia Alexander. His cousin is making those phone calls or text messages with Nilexia Alexander, sometimes in the middle of the night, right? That was all his previous statement, right? And he had never once said anything different. Detective Whelan said every time he was asked about those calls, he said, yes, my cousin, gave a name, Nicole, gave an address as to where Nicole could be found. Suddenly, here in this courtroom, now all of a sudden, Mr. Creed recalls, well, Ronny Walker had access to my phone a few times as well. And that's during the weekend when I was staying with Ronny Walker as well. So the phone communication, right? It's not adding up. It is not adding up with anything that he testified to. It is not adding up with the physical evidence that we have, the phone records that we have. Because if you go back and you look at the records, you're going to see that the contact that first begins between Nilexia and Creed, that contact is an outgoing call from Nilexia to Robert Creed. So if the phone's not ordinarily Ronny Walker's and Robert Creed wants to try and have you believe that this is Ronny Walker using the phone, how is the first communication an outgoing call from Nilexia to Ronny Walker on someone else's phone? It doesn't add up. And again, the timing of all of the calls that I mentioned as well. Is it the cousin? Is it Ronny Walker? The point is that Mr. Creed was all over the map when it comes to this issue. Contact with Robert Parker. This is another big one, right? And Robert Parker, you might remember, that's the person that text message was sent to. Hey, this is Q. Robert Parker is the one where there are several phone calls being made from Erica Sweet's phone to Robert Parker, starting from the night of the murder all the way into the following day. And Mr. Creed's given different answers about this as well, right? His testimony here in this courtroom to you was that he never used Erica Sweet's phone. He's never used the phone. He doesn't have any explanation as to how those messages would have appeared from Erica Sweet's phone. He told you that the messages were sent from Nilexia, and they were sent using Nilexia Alexander's phone, and that the phone calls were made by Nilexia Alexander on Robert Creed's behalf. You know from the testimony and the evidence that none of that is true. There's not a single communication that appears on Nilexia Alexander's phone records to corroborate what Mr. Creed said. And what's more, we know that all of that communication occurs after Nilexia Alexander is dead. So, does Robert Creed's testimony agree with the other testimony and the other evidence in the case? Absolutely not. Then we get down to the actual facts of what happened inside the car, what happened at the time that Nilexia Alexander was shot. Robert Creed would have you believe that Ronny Walker took a gun in his left hand from that front driver's seat. Remember, he's sitting in the front driver's seat. He takes the gun in his left hand, somehow reaches over and turns around to shoot Nilexia Alexander in the back seat of the car. Is that reasonable? Is that reasonable? No, especially when you consider the medical examiner's testimony and the fact that there is no bullet hole, no damage, nothing inside that car. Okay? Remember, Nilexia Alexander sitting in the back of the driver's side. There is one wound and one wound alone to the right side of her body. And that is that shot to the face, to the cheek on the
I tell you, their feed today is really not good.
right? The phone cord and her drink, and get out of the car and scurry over to that empty lot where she was found. So the shot to the cheek is the only shot on the right side of the body. We know that that shot could not have occurred inside the car. In order for Nilexia Alexander to get out of the car, she'd have to be able to move. And so that's where Mr. Terry comes up with his example of, well, isn't it possible that if someone's sitting in the back seat of a car, they see a gun come over to them, they turn towards the gun, and they kind of put their arm up to keep them from getting shot, right? That was the example that he posed to the medical examiner. That's the example he has to pose to the medical examiner. Because to believe Robert Creed, that is the only shot that could possibly occur inside the car. The shot to the back of the left arm. That's the only shot. Because you heard the testimony of the medical examiner. That is the only shot where Miss Alexander would have been able to get out of the car at that point. All of the other shots would have rendered her immediately unconscious. Does it make sense that if someone was pointing a gun at her from the front seat of the car, that instead of turning to her left and getting out, she instead is going to turn towards the gun? That doesn't make any sense. And then again, the physical evidence. Robert Creed testified all of the windows are up. There are no bullet holes or gunshots that go through the window. There's no ripping or tearing in the upholstery. There's no evidence of any sort of gun being fired inside that car. So when it comes down to how the shots occurred, no, the witness's testimony does not agree with the other evidence in the car. You know, Mr. Terry asked some questions about when a bullet is traveling, doesn't it lose some velocity? Sure, it loses its speed. But you heard it also the medical examiner testified this is not a bullet that went through any sort of major artery, did not go through any bones. It went through skin, in and out. So what? The bullet just happened to fall in the back seat of the car without ripping or tearing anything? And Mr. Walker was able to find it and get rid of it before anyone else did? That's not reasonable. Mr. Creed's entire story of how this occurred has reasonable doubt written all over it. But I'll take it even a step further. Why? If Mr. Walker has this grand premeditated plan to shoot and kill Nilexia Alexander, why is he involving a third person? Why is he waking up a man who is sick and vomiting and has a stomach problem and making him sit in the front seat of the passenger car? For what? What purpose would Robert Creed have in the car? That's something that you should consider, right? Is the story that Robert Creed is telling you, is that reasonable? No, it doesn't add up. Also, when you consider the fact that, right, Robert Creed tells you that he was so sick, he was slumped over, he didn't want to be there. Ronny Walker forced him to be there. Why is he texting his cousin to take him to a bar? Because that's what he told Detective Wheeland. Detective Wheeland testified when he confronted Robert Creed about those messages that where Mr. Creed was reaching out to his cousin. Mr. Creed was saying, yeah, I was trying to get a ride to go to the bar. So again, that does not add up. That does not agree with the other testimony and the other evidence in the case. So I'll move on to the next question. Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Well, of course, we know he's never been charged with murder. When he agreed to testify against Mr. Walker, the state released him without having to pay any bond. Now, he's still in jail because he was unable to get an address for his GPS monitor, but certainly if he wanted to get out and had an address, he would be able to. That is a benefit that he received by cooperating with the state. And then, of course, he could be facing up to 30 years. Sure, but you heard him out of his own mouth. He's hoping that at the end of all this, he just simply gets to go home. That's the benefit or that he is hoping to receive. Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? And I'm sure that it wasn't fun to listen to, but that is why I went through every painstaking statement that Detective Wheeland made to Robert Creed during that second interview. And here's an example of just one. If you didn't tell us the truth, you were going to be indicted on first-degree murder. That's the last thing that Robert Creed hears from Detective Wheeland. If you didn't tell us the truth, you were going to be indicted on first-degree murder. So now, Robert Creed is left with that impression that if he doesn't continue with the story that Ronny Walker is responsible for the death of Nilexia Alexander, then he would be the one that could be charged with first-degree murder. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in the courtroom? Well, of course, we know that entire first statement he gives to Detective Wheeland, that is all a lie. He tells Detective Wheeland he didn't know anything about the murder. He doesn't know Nilexia Alexander. He knows nothing about any of this. There's that statement that he makes here that he was sick, he was slumped over in the car, yet he's some reason calling his cousin for a ride to the bar. He acknowledged to Detective Wheeland that was in fact him using Erica's sweet phone to make all of those phone calls and all of those text messages, or that text message to his cousin. He denied that here in the courtroom in front of you. And then, of course, as I previously stated, he now claims that he would sometimes stay with Ronny Walker. When he was previously asked, he stated that he stayed with either his brother or his girlfriend in St. Petersburg. Same thing about the phone, right? When he was previously asked, how is your phone contacting Nilexia Alexander? He didn't say that phone was contacting her because of Ronny Walker. He said that phone was contacting her because of his cousin. Has the witness been convicted of a felony or misdemeanor involving dishonesty or false statement? And for Mr. Creed, he has 21 felony convictions. You are able to consider that when determining his credibility as well. And then finally, that last paragraph about you should consider witnesses' testimony with a more critical eye. Same things I previously said, not facing a murder charge, released without having to pay the bond, and he's hoping to go home. So when you consider Robert Creed's testimony, it has reasonable doubt in all three of those places. It has reasonable doubt in the evidence, right? How he's claiming the shooting happens. He has reasonable doubt in the conflicts in the evidence, the different statements that he gave. And it's got reasonable doubt in the lack of evidence, lack of anything corroborating, anything that he's saying about, oh, it was someone else using the phone other than me. Or, oh, Nilexia Alexander made those phone calls, not me. So let's move on then to Stanley Wilson. Did the witness seem to have an accurate memory? And there are lots of different things that Mr. Wilson and I went back and forth on, and I would ask that you just recall either from your own notes or your own recollection some of the things that he was inconsistent about, but or that he had a poor memory about. And one of those things was, how many conversations did he have with Ronny Walker? Because when he testified on direct examination to Mr. Terry, he told Mr. Terry about one conversation that happens at Ronny Walker's mom's house. And then when I questioned him, I said, well, didn't you give us a previous statement where you said that there were two different conversations, one at Ronnie's mom's house, one at the cousin's house or his niece's house? And then all of a sudden he recalled, oh, yes, there were two different conversations. And then all of a sudden he was able to recall those details. He previously had recalled that conversation happened in the month of May, right? He admitted that. He acknowledged to that. He acknowledged, yes, I previously told you that I had this conversation with Ronny Walker in May before I turned myself in Manatee County. It was only here in the courtroom that he remembered that he turned himself into Manatee County sometime in July, and that the conversation must have happened the day before he turns himself into Manatee County in July. But you heard from Detective Wieland, right? There is no record of Mr. Wilson turning himself into Manatee County on the same day that Ronny Walker gets arrested. And that's significant because no one forced Stanley Wilson to give this statement saying that this conversation happens the day before. Nobody forced him to say that. He said that on his own, emphatically. I brought that to his attention numerous times. He has said, the conversation with Ronny Walker, where Ronny is confessing to me, happens the day before I turn myself into Manatee County, happens the same day that Ronny Walker gets arrested, the day before Ronny Walker gets arrested. So clearly his memory is wrong in that account as well. He told you here in the courtroom that Nilexia Alexander was shot in the cheek. Ronny Walker told him that. But I drew his attention to the fact that I talked to him just a couple of weeks ago, and he previously said Ronny Walker never told him where he shot Nilexia Alexander. Well, now suddenly he remembers, oh, Ronny Walker must have told him, shot her in the cheek. He's previously said that Ronny Walker has never tried to blame this on Robert Creed, and that Ronny Walker has always said that he was the one that shot and killed Nilexia Alexander. He testified here in the courtroom to something different. He testified at first Ronny tried to blame Creed, and then he went ahead and confessed to me. In the courtroom here, Mr. Wilson testified that Mr. Walker told him he turned around and shot Nilexia Alexander, who was sitting in the back seat. But when I drew his attention to a previous statement that he made, he previously said Nilexia Alexander was sitting in the front passenger seat. That's what Ronny Walker told him. So again, all of these contradictions in his memory as to the facts that he's claiming Ronny Walker told him. Was the witness honest and straightforward in answering the attorney's questions? Again, that is a credibility issue, a judgment call that you all get to make. Did the witness have some interest in how the case should be decided? And he told you about his plea agreement, that he has pled guilty here in Hillsborough County to 5 years in prison. He should have been doing 10 years, but they gave him a break, and they're holding that sentence over his head, that they can come back and they can give him the full 10 years if he does not come in here and testify against Ronny Walker. Does the witness's testimony agree with the other testimony and the other evidence in the case? There's no evidence that Nilexia Alexander, Ronny Walker, or Erica Sweet had any kind of STD. Erica Sweet was on the witness stand. Certainly, the state could have asked her. You heard the testimony of the medical examiner. No evidence that Ronny Walker had any kind of STD, right? So sure, Stanley Wilson is saying these things. He's saying that, oh, this is what Ronny Walker told me, but there's no other evidence to corroborate that. Robert Creed doesn't corroborate that. Robert Creed doesn't tell you that they're arguing over some kind of an STD. Robert Creed says there's one thing only that is said by Ronny Walker. Are you having sex? Nothing about an STD, right? Now, the state wants to read that into he was talking about an STD. There's no evidence of that. There's no proof of that. Certainly, if Mr. Creed had heard something about an STD, you would have heard about that too. And then again, there's this timeline that Mr. Wilson is completely off on. Because remember, he says that the conversation with Ronny Walker, where Mr. Walker confesses to him, this happens, and it's premised on essentially three. Robert Creed out of Pinellas County. Well, I guess Mr. Walker must have had his magic ball on his hand, because remember, at that time, when this conversation is supposedly happening, there hasn't even been an arrest warrant out for Robert Creed, let alone the fact that Robert Creed wasn't arrested until several weeks later at the end of July. This isn't a situation where Mr. Walker is saying, oh, I think you're probably going to need to help me out with a friend. No. Stanley Wilson testified that Mr. Walker specifically told him, Robert Creed's in Pinellas County. I need you to help bond him out of Pinellas County. Again, none of the evidence complies or comports with that. Mr. Terry told you when he got up here an opening statement, right? Mr. Wilson is a con man. And you heard the situation that Mr. Wilson was in when he decided to contact the state of Florida to tell them about all of this wonderful information that he had. He was about to have his bond revoked. He was about to go to prison. So, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Yes. The second he gave that statement, he is no longer facing the penalty of having his bond revoked. That is withdrawn by the prosecutor's office. Again, he was facing 10 years in prison. He got about half of that time. The rest of it is being held over his head. Had any pressure or threat been used? Yes, we talked about the 10-year prison sentence. Did the witness at some time make a statement that is inconsistent with the testimony he or she gave? I'm not going to repeat all of the things that I previously said, but we talked about that when we discussed his memory or lack thereof. Has the witness been convicted of a felony or misdemeanor involving dishonesty or a statement? 171 felonies. Now, what that means is up to you, right? You can determine how significant that is. But clearly, it is a consideration that the law is telling you you can consider. Just think about that, right? Why are you being told this is something you can consider? 30 misdemeanor crimes of dishonesty. That is the caliber of the witness that the prosecution has brought before you to prove Mr. Walker's guilt beyond a reasonable doubt. 171 convicted, felony convicted, con man, Stanley Wilson. That long paragraph about benefits and such and considering testimony more critically, Mr. Wilson was desperate to speak to the state attorney's office. He made a phone call himself And then he made sure his attorney followed up as well. Again, because he knew what kind of a situation he was in. That motion to revoke his bond was then withdrawn, and that 5-year prison sentence was offered. Stanley Wilson's statement has reasonable doubt written all over it. It is no coincidence that when I sat up here and I went through all of the details that he gave about the actual shooting, right? About it happening, where Nilexia Alexander was shot, where the car went afterwards, all of those things were in a news article, a very detailed news article that was printed just before he picked up the phone to contact the state attorney's office. And that may sound silly, but remember who we're dealing with here. We're dealing with Stanley Wilson, right? The guy who wheels and deals, sells insurance, and pretends to be a bondsman and all of those kinds of things. Something else you should consider when it comes to Stanley Wilson's testimony. He told you straight up, he didn't really know Ronny Walker. He knew Mr. Walker's family. So if he doesn't know Ronny Walker, is it reasonable to believe that Ronny Walker is going to walk up to him and say, hey, I killed a girl. I need your help trying to get out of it, and give this full confession, giving him every detail from I shot her in the cheek to, and then I tried to blame it on Creed. And, oh, but Creed, I gave him a description of Creed's son. Oh, and Creed's son, he has dreads. Oh, but Creed, my friend, the real Creed, he's bald-headed. Does that sound reasonable that this is the conversation that's going to be happening? Or does it sound more reasonable that Mr. Wilson read some of those details in the article and he then claimed that Mr. Walker gave him a confession? That's what's reasonable. Did Mr. Stanley Wilson, did he give every detail that was in the article? No. But go back and look at your notes and ask yourself, was there a detail, a verifiable detail, right? Not a gun being thrown into the Hillsborough River, but a detail that you know from somewhere else in the evidence. Is there a detail that he gave that was not in that news article? No. So I want to move on then to talk about the investigation. And I want to be clear about something. Detective Whelan's not a bad person, right? When we talk about the investigation, I'm not trying to convince you that he's not a good person or that you should dislike him. I am talking about the caliber of the investigation that was conducted here. I want to be perfectly clear about that. When I asked Detective Whelan about the reasons why he issued a warrant for first-degree murder on Mr. Walker, he gave me his list of reasons, right? We've got Robert Creed's at the gas station. Or I'm sorry, Ronny Walker's at the gas station, but we also know that Robert Creed's at the gas station. He told me, well, Ronny Walker's in this car where Nilexia Alexander's phone is traveling with it, but we also know Robert Creed is using the phone to contact Nilexia Alexander. I'm sorry, he's using the phone to contact Nilexia Alexander. We also know Robert Creed is using Erica Sweet's phone to contact his cousin. We also have Robert Creed on the video at TGH, right? And we also have Robert Creed in Ronny Walker's car at all times during the investigation. So everything that he told me about Ronny Walker and the reasons for the arrest of Ronny Walker, each and every single one of those things is true as it pertains to Robert Creed. So why is it that Ronny Walker is sitting here and not Robert Creed? You've heard through the statements that were introduced of the things that were said during that second interview with Robert Creed. They were desperate in the investigation at that point. They needed answers. They needed to know who their trigger person is. They needed someone to tell them who the trigger person was. And so Detective Whelan went about the way that he went about it, lying, using pressure, telling Mr. Creed he could be arrested and charged with first-degree murder if he didn't give the statement at that time. Those are all the tactics that were used by Detective Whelan, right? He was putting pressure on Robert Creed. Robert Creed asked if he can get an attorney. Detective Whelan says,
yeah, we can get you an attorney, but I'd rather get the ball rolling on this statement. And ultimately, Robert Creed agrees. Okay, yeah, let's just get the ball rolling on the statement, right? Detective Whelan approaches this interview very differently from other interviews. In other interviews, you heard him say, yeah, we don't give out a whole lot of information. I want to know what the witness knows before I tell them anything. And that clearly was not the case. Mr. Creed was spoon-fed the information that Detective Whelan wanted him to have. And Robert Creed gives Detective Whelan about information. Right? That phone contact between Robert Creed's phone and Nilexia Alexander, it's not nothing. It is something. It is significant. But as significant as that is, Detective Whelan doesn't see fit to follow up and to see if what Robert Creed is telling him is the truth. He doesn't follow up to talk to Robert Creed's cousin, Nicole, doesn't even try to look for her. It's not as though he tried to find her and couldn't find her. He doesn't even try to look for her to verify what it is that Robert Creed has told him. The investigation, the way that it was went about, the tactics that it was used, all set up. They were all set up to appear the way that they appear here today, which is that they have their witness coming in to point the finger. Because if they didn't have a witness to do that, then it's nobody. Then they can't prove anything. Ms. Fawcett talked to you about first-degree premeditated murder, so I'm not going to spend a whole lot of time going through the jury instruction with you. But what I am going to tell you is that you obviously will have a definition of what it means to be first-degree premeditated murder. And what I'm going to ask is that if you find yourself in a situation where you are looking at the charge of first-degree murder because you believe the state has met their burden in proving that Ronny Walker is guilty of killing Nilexia Alexander, that you also then consider the entire law, including the lesser included crimes. The lesser included crimes are going to be that of second-degree murder and manslaughter. You're also going to be given an instruction by the judge about adequate provocation and heat of passion. Adequate provocation and heat of passion will have steps for you to follow where you can look at and see, okay, if I do think Ronny Walker did this, then is there adequate provocation? Was there an argument that was happening and this happens out of heat of passion? So I would just ask that you consider all of the law if you find yourself in a situation where you are considering that. Tampering with physical evidence. Again, the evidence in this case essentially is going to come down to Robert Creed and Stanley Wilson. When it comes down to the evidence about cleaning the car, getting rid of any kind of evidence or something like that, you're essentially left with Mr. Walker's boss from the Giant Motors, right? Where he said, yeah, we saw him taking a long time cleaning the car one day. Yeah, it could have been a little bit odd. But he didn't tell you when that happened. He couldn't remember. We don't know if that but they have not proven to you beyond a reasonable doubt that Mr. Walker actually did anything to clean the car in an attempt to get rid of evidence from a homicide. They have not provided any information or any proof to you, verifiable proof, that he got rid of a murder weapon, that he picked up shell casings from the ground and got rid of those, or that he threw Nilexia Alexander's phone out the window or got rid of it for some reason. You know, what's interesting about Nilexia Alexander's phone is that it basically stops communicating with cell phone towers very shortly after that Tampa General Hospital video. Who do we know that gets in the back seat of the car at the Tampa General Hospital? It's not Ronny Walker, Robert Creed. Right? So that's something to consider. Did Robert Creed discover the phone? Did he get rid of the phone? I want to go back to that reasonable doubt instruction. Plea of not guilty, reasonable doubt. if after carefully considering, comparing, and weighing all of the evidence, you do not have an abiding conviction of guilt. Rather, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find him not guilty, because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. When you go back into that deliberation room, ask yourself this question. Is it reasonable? Is it reasonable to believe that Robert Creed is the one that killed Nilexia Alexander? And if when you ask your question, if you ask that question to yourself and your answer is, it's reasonable, then you have a reasonable doubt. The state of Florida has not provided you with the tools necessary to prove that Ronny Walker is responsible for the death of Nilexia Alexander. They have failed to do that. Their case boils down to Robert Creed, who doesn't want to be charged with first-degree murder, and a con man who concocted a plan to keep himself out of trouble. That's what their case boils down to. And then lastly, if you find yourself in a situation where you do think it's reasonable Robert Creed shot and killed Nilexia Alexander, that's when you consider that principal theory that the judge is going to instruct you on. But I want you to pay attention to the law that the judge is going to give you on mere presence. Mere presence at the scene of a crime is insufficient to find a defendant guilty of that crime. Likewise, knowledge that a crime was occurring or was about to occur is insufficient to find the defendant guilty of that crime. This remains true even if the defendant fled from the scene of the crime. And I'll just stop there. If you find that you believe Robert Creed did in fact shoot and kill Nilexia Alexander, then the question will be, did Ronny Walker do anything to help him? And the answer to that question is no. Right? You would have to find under that principal theory that Ronny Walker knew that a first-degree premeditated murder was going to happen. Not that he thought it was maybe, something kind of odd going on between Mr. Creed, who's, an older man, and a young 14-year-old girl. Not that he thought that that was weird, but that he knew that Robert Creed intended to kill Nilexia Alexander. And he drove Robert Creed and Nilexia Alexander to this location for that purpose, to kill Nilexia Alexander. There's no proof of that. There's no evidence of that. You heard Detective Whelan. There's no evidence that Robert Creed did anything wrong other than lie to them in their investigation, right? So how can the state of Florida come up here with a straight face and ask you to find Mr. Walker guilty of a crime, not because he killed someone, but because he helped someone kill Nilexia Alexander? That defies all logic. You can use your common sense when you go back there, and I ask very much that you do so. You heard the testimony. First of all, Ms. Fawcett repeatedly referred to this as an abandoned area or a desolate area, something to that nature. You saw the neighborhood. You saw the houses surrounding the area. You saw the lights on the street. This is not an abandoned area. Even more, you saw that the car did not stop at the dead end of the street. Rather, the car drives towards the middle of the street by that abandoned lot. So it's not as though Mr. Walker would have driven the car to try to conceal it because he knew a first-degree murder was about to happen. There's no evidence on the record, right? That their evidence is one of two things. Ronny Walker did it or he didn't. That's it. There's no evidence that he helped anyone else commit a crime, that he knew that a murder was about to happen. In closing, I would just like to remind you of that presumption of innocence that Mr. Walker started with. The presumption that remained with him through each and every witness and each and every exhibit, each and every piece of evidence. that presumption is still with him even now because the state has not proven their case. If you go back there in the deliberation room and you find yourself on the fence, you're not sure, you're going back and forth. Well, maybe Ronny Walker did it, but maybe Creed did it. They both could have had access to do it. I'm not sure. Those are all reasonable doubts. If you find yourself back there in the deliberation room, asking yourself, going back and forth, I can't believe what Robert Creed is telling me because none of that is credible or believable. I don't believe Mr. Stanley Wilson, because none of what he's telling me is believable. That, again, that is reasonable doubt. Ronny Walker is innocent. He is not guilty. I am asking that you return the only verdict that is supported by the facts and the evidence in this case. That is a verdict of not guilty as to each count. I thank you very much for your time and attention.
Gary? Yes.
So the defense is done here in regards to their closing argument. And what do you guys think? Oh boy, I tell you, the tension, I know nerves in that courtroom have to be all over the place in regards to what the jury is going to decide. Drop in the chat what you think in regards to the closing arguments. Did the prosecution prove, or did the defense poke those holes? Remember, it only takes one juror to find him not guilty or find some reasonable doubt or not be convinced. And we're talking about a death penalty case. In order for him to be not convicted. Okay, guys, I'm going to go ahead and play it. Let's. Well, it looks like they're going to a sidebar. So we'll see.
Ladies and gentlemen, before we do the last 45 minutes of this, we're going to give you all about a 5-minute break. You drink, sit back in. Thank you.
All right, for the jury. Be seated.
Court's in recess, y'all may be seated. See you all.
So I guess we're going to be looking at the time for 5 to 10 minutes while they take a break. I did notice that the judge said we're going to take a 5 to 10 minute break before we do this last 45 minutes. So I guess he assumed the next portion, the time that he has allotted was 45 minutes. While they take a break and we're looking at the symbol, I am going to go grab something to drink, guys. And go get me some more coffee and warm it up, because it looks like we'll have another 45 minutes or so. Hopefully they only stay gone for 5 to 10 minutes. I encourage you, take a break and get you something to drink. And if you're at lunchtime, like we are currently at here in Mountain Standard Time, grab you a bite to eat, maybe some popcorn, and let's see what these last statements are going to be about this last 45 minutes. But hopefully hopefully the time is the 5 or 10 minutes. We'll see. Okay, guys, give me 1 second here. I am going to go grab me something to drink, and yeah, that's what I'm going to do. Drop your thoughts in the chat room. Don't forget to like, subscribe, and share. We're growing over here. Hi, welcome in. We're just waiting for them to resume from their break. It was supposed to be 5 minutes. I am here. Y'all see the live feed. It just says court will resume shortly. So soon we'll be back in court. As you come in, let me know where you dropping in from. Post your comments in regards to how you feel the prosecution is doing, and also in regards to the defense's case. Is he guilty or not guilty? These are questions that I have for you guys. You be the judge in that regards. Very interesting. Very interesting. We shall see. The jury will have it very soon. Remember, Ronny Walker is on trial for capital murder. So it's a death penalty case. So the jurors have his life in their hands as we speak soon. There's the defendant, accused of killing, murdering Nilexia Alexander. She was only 14 years old. You know, they don't show many screenshots of him in court. So this is interesting to see. They must be about to bring the jury back in and resume fairly shortly. I see everybody kind of like sitting down. So we should be going back on the record fairly shortly, within a moment. You know, I wonder, like, even with the evidence that the prosecution have, what do you think? Do you think the defense has raised any reasonable doubt? If you were a juror, what would your decision be?
All rise for the jurors.
Jury's back, y'all may be seated. Welcome back, ladies and gentlemen. Once again, I asked you if everything was okay with the court's instructions, no issues, nobody had any problems, no media. Very good, thank you, folks. Mr. Taylor.
Thank you, Your Honor. Good afternoon. So I want to start this before I get into some of the other points I was going to make by starting off real quick with something Ms. Dunker had said, and in fact was crystal clear from watching her closing. This case does not come down to whether or not you believe Stanley Wilson or Robert Quincy Creed. It does not. She wants to put it all on that. But ladies and gentlemen, don't forget, Ronny Walker was charged, arrested, and indicted before Quincy Creed or Ronnie or Stanley Wilson ever said a word. He had already been arrested. He had already been indicted. She wants to make it sound like Jake Whelan was desperate trying to get Robert Quincy Creed to say what happened. Jake Whelan wasn't desperate. He'd already arrested Ronny Walker for this murder. He'd already been indicted. He wasn't desperate. Sure. Did he want to find out the truth and he believed he was going to get it ultimately from Creed? Yeah, but he'd already arrested him. He'd already made his case. And I'm going to get back in a few minutes to why that is. But I wanted to make that very clear right now from the start, because that was the almost 90% of the closing that Ms. Dunker did had to deal with whether or not you believe them. And I'm going to tell you that there are reasons you should believe them. And I'm going to get into those specific reasons in a little bit. But what I wanted to make crystal clear before I even got into that is that is not the truth. We are not relying solely on that. That is not the truth. So let me go start. And I'm going to go into real quick into Quincy Creed. Okay, we'll talk about him real quick. And something that came up in this that I thought was really interesting. All right. And there's, in doing this job for as long as I've done it, I find that, you can ask questions and ask questions and ask questions and ask questions and not get anywhere. Sometimes all it takes is asking the right question. And guess what happened in this case? Detective Whelan never asked Quincy Creed the right question. Ms. Dunker never asked him the right question, and I never asked him the right question. Not until he was on that stand and I'm doing the direct that I thought, did you ever, because he clearly lets people borrow his phone. You can hear how he talks about it. Like, oh, I guess my cousin had it. So-and-so had it. People had his phone. So it occurred to me. So I wonder if anyone's ever asked him if Ronny Walker ever used his phone. So I asked him. And he said, yeah, he uses my phone. Oh, that explains something. Because that had always been a little bit of a strange quirk in this case, is that Nilexia had contact with Quincy Creed's phone. But there's no other evidence of any other contact between those two. He doesn't live in that neighborhood. It just didn't make any sense. And Creed did say that he had believed that maybe it was his cousin who he borrows the phone from, who's around that same age. Maybe she did it. But no one ever thought to ask. And then when Ms. Dunker got up on cross and said, well, you've never said that. What did he say? You never asked. That's how simple it was. You just never asked. And that cleared up so much.
It's not me. It's definitely them. Hopefully it's just like a glitch like it did earlier. And hopefully they'll be right back in there. I think
Next
cameras
right
have
question.
issues.
Where were you staying that weekend? I was over. Because I've been staying on his sofa. Oh. So that was interesting. But then it turns out that Ronny Walker didn't even have a working phone around that time. makes even more sense. And then ask yourself, Ronny Walker is doing something with this young girl. Do you think he wants his wifey to find out? Do you think he's going to use Erica Sweet's phone? His phone's not working. Whose phone do you think he's going to use? He's going to use Creed, his friend, who, ladies and gentlemen, I mean, we need to be clear. You can tell he's not the brightest individual. And it's very clear that Ronny Walker was using Creed in many aspects in this case. But the right question, it was never asked. So when Ms. Dunker gets up here and says, oh, he's now suddenly remembering something. No, he never said he didn't remember it. He just said to her very simply, you never asked. He's not a brilliant mastermind trying to frame somebody else. If he was, he probably would have volunteered that a long time ago. I guess the defense would have you believe that Robert Quincy Creed shot this girl and then is coming up and framing Ronny Walker, or is blaming him, or is, because he's the one who did it. Does Quincy Creed seem that smart to put that together? And ask yourself this too. You heard his description of the shooting, right? He's in the passenger seat. He's not feeling well, which is another interesting fact that he kept bringing up. So clearly this is something he very much remembers, that he wasn't feeling well and didn't want to go out. But he felt an obligation to Ronny Walker because he was staying at his place. This is a drifter. He's drifting around, couch surfing, staying with his brother, staying with a girlfriend in St. Pete, staying with Ronny Walker, staying wherever he can stay, really, okay? And he describes the shooting, and he says that he had his head kind of leaning towards the window. Like, imagine when you're sick and you're not feeling well. That's what you do. That fits. He hears a bang. But here's the argument. He hears Ronny Walker ask him if she's having sex. And then he hears the bang and turns and sees her like this and thinks she's shot in the chest. And then he says, Ronny Walker has her get out of the car, and he hears 2 more shots. Can't say where she was shot. Well, he's wrong on the shots, and he can't say where she was shot. Don't you think the shooter would know where she was shot? Don't you think the shooter, if he's trying to blame someone else, is going to give you the accurate information about how the shooting occurred to make it look even more like the other person did it? No, he didn't know, because he was sitting in the car. And Ronny Walker gets out and shoots her. He didn't know she was shot in the head. He didn't know where she was shot. That's why he couldn't give you that information. Ms. Dunker never discussed that, but let's be clear. He didn't know how the shooting occurred. And his description of shot in the chest, which isn't true, and the 2 shots outside the car, which isn't true. There were 4 or 5 more shots outside the car. If Robert Quincy Creed really wanted to blame Ronny Walker and make this about Ronny Walker, he would have given the true facts of what happened, because the shooter would know. The shooter would know where the person was shot, because the shooter aimed at the person's head. But Creed doesn't even know. That is further proof that Creed was here telling you the truth. He's telling you what he knows. And yes, he was less than cooperative at the beginning. Less than cooperative, but imagine, he's just witnessed a murder. This man shot a 14-year-old girl. What's he going to do to him? So he's going to keep his mouth shut. He knows the score. Just keep his mouth shut. I'm not going to say anything. If I'm confronted, I don't know anything about it. I don't know anything about a murder. I don't know anything that he did. And yes, it took a while with Detective Whelan to get him to come around to see, you should cooperate. Could Whelan have charged him? No. Mere presence, ladies and gentlemen, we could not and did not ever charge Robert Quincy Creed because there's nothing to connect him to this case other than that phone call, which now we know could just as easily have been Ronny Walker making those phone calls. There's nothing else linking Creed to doing anything in this case. Ronny Walker did a bunch of stuff, which I'll get into in a minute, but we can't show whatever Creed did. If Creed was just sitting in that passenger seat with his head against the window as he describes, then that's mere presence. there's no chance of convicting him. You heard Detective Whelan. Nah, I couldn't have charged him. I wasn't going to charge him because he knew. He knew you couldn't charge Quincy Creed with this. Just because her number is in that phone for a few times during a short period of time, it's not enough to charge a passenger of a vehicle where a woman or a girl gets shot. It's just not enough. And he knew that. But the driver, we'll get into that in a minute. Much more there. So Creed has told you what he remembers about it. And granted, like I said, some of those facts don't fit up, but if he wanted to really blame him, don't you think he would have told exactly what happened? He didn't. He told what he knew, what he remembered. Don't you think he would have blamed Ronny Walker a long time ago for the numbers in the phone? If he had been a, criminal mastermind who was wanting to blame Ronny Walker for this? No. Didn't ask the right question. Finally, somebody did. Finally, we asked that right question. And that led to the next question. Where were you when those calls were being made? Oh, actually, I was staying at Ronny Walker's house during that time period. Not even Ronny Walker's house. His girl's house. Ronnie's girl's house. That's how he described it. Wouldn't even go even to blame Ronny Walker at that point. He's still talking about, I was just at Ronnie's girl's house. I don't think he even understood the importance and the relevance of what that information meant. He didn't get it. He wasn't trying to help the state. He wasn't trying to make up a story. He'd just never been asked. Asking the right question. So, let me go back to Creed's description of the shooting in the car, because there was some, Ms. Dunker got into that a little bit and said how unrealistic that is. She's going to lean into the shot. I never said she leaned into a shot. If someone is reaching around from the front seat like this with a gun, and you're kind of leaning over, looking at them, and all of a sudden you see the gun, what is your instinct to do? Duck. You duck down. And she's sitting there like this. She leans, she's like, ah. She ducks, and it goes right there, right through her back. It makes perfect sense. It fits the others perfectly. And you heard from that medical examiner, yeah, that's definitely possible. That definitely could have happened that way. Absolutely. You turn and duck from a shot. You protect yourself. You protect your body. You turn. And that's what she did. She covered herself. And then she comes up like this and shot. And that's why Robert Creed thought she was shot in the chest, because she's holding her chest. But she was shot in the back. How else do we know she was shot in the car? And I'll get back to in a second ago why there was no projectile found or no damage to the car. Common sense will tell you why, but I'm going to get back to that. How else do we know she was shot in the car? Well, you heard Creed. She gets out on her own. Ronny Walker tells her to get out, and she gets out of the car at that point. Clearly, of course, she's been shot. But there's blood in the car. Right there, right by the little door where she was sitting, because she's bleeding already. Look at the pictures from the crime scene. Look at the blood droplets right along the road, on the leaf, all leading to where she was ultimately murdered. She was walking, ladies and gentlemen, and she was dripping blood as she was walking. She was alive. She had been shot. She was walking away into this field. The evidence, the physical evidence at the scene corresponds to that. That bullet traveled across her shoulders. It came out one side. That bullet traveled a long way through her body. And yes, it didn't hit an artery or a bone, but it went through, you heard the ME. It went through muscle, subcutaneous tissue. That bullet lost velocity as it travels through the body. It had to break the skin originally, go through all that muscle in the back, go through the subcutaneous tissue, and then break through skin again to come out. Its velocity's gone. It's not going to damage anything. It's going to drop right there on the seat. You saw what happened to the other projectiles, right? Where she was shot in the head out on the vacant lot. Feet from her. Because it went through her head, lost velocity and fell right on the ground. It did go 20 feet away. It did go into a house down the street, because when a bullet goes through a body, common sense tells you, ladies and gentlemen, it loses its velocity. And those bullets lost their velocity, and the bullet in the back dropped inside that car. And somehow, Ronny Walker found that bullet and cleaned it before the police did. So no, it didn't have the velocity to go into a seat or to tear anything up, because the body, Nilexia Alexander's own body, had taken all the energy out of that bullet. So yes, she was shot in that car just as Robert Quincy Creed describes. It fits perfectly, exactly, the way a person would react when faced with a gun in their face. The way she got out, the blood drippings, all of that fits for what was Nilexia's last moments of her life. Before that man right there put those final bullets into her head. How else do we know she was shot in that car? Got the droplets of blood. Look at those pictures. You will not see a single drag mark. You heard from the medical examiner, she was shot in the head in that car. She would have been unconscious. There is no way they could have gotten her out there without dragging her or lifting her or doing something crazy with her. But there's no drag marks. There's no heavy, foot dragging, nothing. She walked to where she was ultimately executed. How else do we know she was shot in the car? Well, someone was pretty anxious to clean that car up. There's 2 bottles of carpet and stain cleaner. Not just 1, 2. 1 with his fingerprint on it. Someone had been cleaning those seats, cleaning those carpets, but didn't think about the outside of the door. He missed a spot. He missed a spot. That's what happened. And that spot was the blood of Nilexia Alexander. Let me talk to you briefly about Stanley Wilson. And again, I'm going to go back to what I said at the very beginning of this. State doesn't need Stanley Wilson's testimony. You don't need to believe everything Stanley Wilson said to find him guilty in this case. Not at all. And now, I submit to you, there's reasons to believe him. He had a close family connection. He was dating and going out with the niece of Ronny Walker. He was working in the bond field, so it makes sense that Ronny Walker would want to go talk to him about it. And he gives a statement that gives a motive. Now, we don't have to prove motive. That's not even required. But I think the importance of that statement is, as Ms. Fawcett said on our initial closing, is it corresponds with, again, what Robert Creed said he heard Ronny Walker say. Are you having sex? In a very angry voice. Why is he saying that to her? Why is he mad at her? Well, if he believed she had given him an STD, that would probably make him mad. Especially if his girlfriend's saying something about it. Now, do we know whether Ronny Walker had an STD? There's no evidence of that. Do we know whether Erica Sweet had an STD? No. And do you think if we asked her on the stand, she'd say, yes, I have an STD or I had an STD? She's not going to say that. For the same reason, Erica Sweet is never going to say that she knew Nilexia Alexander. You saw how many times she called that man? She was in love with that man. She's not gonna, oh yeah, I knew Nilexia. Well, she knows that if the minute she says that, that's all over. It's all over for Ronny Walker. But you heard from Stanley Wilson, he saw them together. He saw them actually fighting one time, Nilexia and Erica Sweet. Again, a lot of things he said that were not in the paper. Says the gun was tossed in the river. When you look at the videos that were put together by Sergeant Van Heist that show the car and where it goes. And you'll see the little cell tower sites and stuff. I want y'all to watch it at one point. You'll see after it leaves the homicide scene, it kind of does that kind of crazy little turnaround, da da da. But then if you watch it, look at it on the map. It's right next to the river for a while. It's right next to the river for a while. He got rid of that gun in the river. The divers just didn't know the right place. But Stanley Wilson knew that he got rid of the gun in the river. Look at that. Watch that video. You will see that it stops right just north of the Columbus Bridge for a while. That phone is sitting there, at least 5 or 10 minutes, hitting off the same cell tower, very close, almost like right next on the riverbank. Ronny Walker was getting rid of that gun. Miss Dunker got up and said, "Why was Creed with Ronny Walker that night? Why would he bring Ronny Walker? You're going to go kill some girl. Why would you bring Ronny Walker?" Ladies and gentlemen, you know, some defendants may manufacture an alibi. Ronny Walker was manufacturing a scapegoat. He knew if he had someone else in that car, especially someone as simple as Robert Creed, that God forbid he ever gets caught, he can always blame somebody else. He directed that perfectly. He knew that by having someone else in that car, he had someone else to blame. He manufactured a scapegoat in this case, and that scapegoat is Robert Quincy Creed. Who controlled that car? Ronny Walker. Who decided where that car was going to go? Ronny Walker. Who parked the car the way it was parked? Ronny Walker. Who drove it away with the lights off? Ronny Walker. Who was wearing a dark coat with a hood that night? Ronny Walker. Did you see the pants that Robert Quincy Creed's wearing? Those shorts down to his ankles and like all around his kneecaps. Does anyone think he could have gotten out of his car and hobbled around and confronted Nilexia Alexander in clothes like that? Those clothes aren't in any way. He would never be able to chase down Nilexia Alexander and shoot her in the head. So yes, that's why Ronny Walker bought Creed. He brought him so that he always had someone else to blame, should God forbid they ever find out he did it. Now, like I told you, Ronny Walker was charged with this crime before we even heard from Robert Quincy Creed and what he said about how the shooting occurred. Ronny Walker was charged with this crime before we ever heard from Stanley Wilson about a potential motive. Ronny Walker was charged with this crime because Ronny Walker was a principal. And why do I say that? And I'm not saying he didn't shoot her. He did shoot her. The state is never for a second telling you that Robert Creed did it. There is absolutely zero scintilla of an evidence to suggest or put Robert Creed as the shooter. There just is not. But even if you stretch your mind enough to think that Robert Creed is some sort of mastermind who planned all this and did all this, and Ronny Walker is some dupe who ended up having to drive him there, it doesn't make any sense with how the drive occurs. Look where they go. She is picked up right near Erica Sweet's house. And you heard from Creed that he was driving around looking for her. He was asking people, have you seen that girl? He was hunting her. And they drive around and Ronny Walker goes and gets her a drink. And as Ms. Fawcett said, do you think she's going to get in a car with a driver that she doesn't know? Now, granted, she's made a lot of poor decisions in her life, but she knew who Ronny Walker was. She wouldn't have gotten in that car if she didn't. Ronny Walker was the driver. She gets right in there behind him in the driver's seat, behind the rear driver's seat. Ronny Walker drove to that location. Why? Why that location? Because it's dark, It's quiet. It's got a vacant lot. Easy place to kill and dump a body and get out of there before anyone finds you. It's not on a major thoroughfare. Not where people are going to find you. He knew that he'd have time once she said to get out of there before anyone, police, anyone would come around. And we know it was over an hour or almost an hour before the police actually were able to get there. 40, 50 minutes, something like that. He drove to this dead-end street, turned the car around and drove so that her side of the car was right next to that vacant lot, make it easier so he didn't have to walk around the car, get her around the car, get her to the other side of the car. He knew right there, put her right by the street. That shows, ladies and gentlemen, circumstantial evidence that he knew what was going to happen. He knew. So even if you stretch it and say, well, maybe Quincy Creed was angry at her and was going to shoot her for some reason. How did Creed get there? He can't even drive. Oh, he needed the help of Ronny Walker. So Ronny Walker aided, assisted, abetted him in getting this 14-year-old girl to this vacant field. If you were to stretch your mind and try and say, well, maybe Creed did it. Even though but if you were to even go so far as to presuppose that Ronny Walker drove that car, drove to that location, put that car in the exact spot, and then you see it on the video, drove away, turning the lights off as they're driving away. Assisting and aiding the murderer get away. The murderer was himself, but even if you want to believe it was Creed, he was assisting Robert Creed in committing this murder. He is a principal under the law. And you'll have the instruction. You'll see what it says. But he was a principal, ladies and gentlemen. He drove, he assisted, he aided. If, and again, it's hard for me to even make this argument because the state is telling you that it was Ronny Walker that shot that gun. We are not backing away from that, even in the slightest. So I urge you not to think that just because I'm saying this, that we're telling you that it was Creed. We are not. Not under any circumstances. However, that did it, or possibly Creed that did it. But even if you were to let yourself go to that level, Ronny Walker aided and abetted this murder. He's just as guilty as the murderer if you were to stretch your mind that point. That is the principal theory. He drove her there, he drove away after it was done with his lights off. He got rid of evidence. He lied to the police when they came to him. Ronny Walker is guilty under the principal theory, but he's also guilty because he did fire those shots. No evidence Creed ever drove that car. The DNA on the driver's side, not Robert Creed. On the windows, things and everything, not Robert Creed. You see him in every place you see Robert Creed, he's in the passenger seat. And he gets out of the passenger seat and even goes to the back seat when he's told to, because that's Ronny Walker's car. He's the one driving that car. He's the one controlling that car. He's the one controlling everything. Go over a couple of other little points that Ms. Dunker talked about. She talked about all these calls and texts to Robert Parker about going out. Don't forget, the majority of those calls from Erica Sweet's phone to Quincy Creed's cousin were done the next night, the 7th. They weren't even done when they were out. There were about 4 or 5 calls, you can see for yourself, where to Robert Parker soon after the murder. And more than likely, you can imagine that you just witnessed your friend shoot someone and you want to get out of there, you know? So you start calling somebody you know to maybe like, maybe I can go get with Robert and get out of here. Right after the murder. You think if you just shot and killed someone, you're thinking about calling a friend to go hang out? He's calling trying to find a way away from Ronny Walker. because now he's in it. He's just witnessed Ronny Walker kill this girl, and now he's telling him, keep your mouth shut. She talked a lot about these witnesses that we have. And again, ladies and gentlemen, we can't pick the witnesses. I told you this when we were doing our verdicts. I wish all my crimes would occur in front of, the Pope, or mayor or somebody, but they don't. They occur amongst the people where crimes occur. Other criminals, most of the time. So we can't pick and choose them. But you also know that you can believe or disbelieve all or anything they said to you. And again, the little details that Robert Creed gave, match. Feeling sick and putting your head down. That's something that when you're feeling sick, that's something you would do. The way she was shot and how she came up and how she's holding her chest matches. Getting out of the car.
Can we approach Judge?
Yeah.
Windows. They put their heads on something cool to kind of, when they're not feeling good. It just kind of fits what he's saying happened. Those little details that not someone, especially not someone like Robert Creed, could think of. The question he said to her before he shot her. The fact that matches up with what Stanley Wilson said the motive was. All of those little details show you that. Now, maybe they weren't both of them being entirely truthful. Stanley Wilson couldn't remember some things. Remember, he told you, or he said that when he gave that deposition, it was just a couple of weeks ago, and his proffer was back in August of 2022. It's been a number of years. He was never shown his proffer before the deposition, never had a chance to refresh his memory about those kind of things. So yeah, were there some inconsistencies? Absolutely. But that doesn't mean just because there were some inconsistencies that you don't have to believe the big things he said, because he's always been consistent on that. He has always been consistent that Ronny Walker shot him. He has always been consistent about the reason that Ronny Walker shot her. All of those consistencies stayed. The article that Ms. Dunker referred to, saying he was just like the article, I pointed out all the different things he said that were never in that article. And the description of Robert Creed was never in that article. And he never met Robert Creed before, so how would he know that Robert Creed is thin and bald? It's not in the article. I went straight to that article, read the line where it describes the son, never describes what the father looks like. But Stanley Wilson knew. How did he know? Because Ronny Walker had told him. Yeah, I said it was his son. He's got these big dreads. It wasn't his old man who's thin and bald. It's the only reason he knew that. Little details like that, ladies and gentlemen, that show you, even if you've been a convicted felon, and every single one of you agreed that you would listen to a person, even if they've been convicted of felonies, and judge them based on how they testify, how it corresponds with the case. And I think if you look at it, those little details all match up. Ms. Dunker said something earlier too she said, if you find a committed first-degree murder, you also need to look at secondary murder and manslaughter. That's not true. If, ladies and gentlemen, you go back there.
Judge, objection. It's an improper argument and mischaracterization of my argument, Judge.
I'll overrule the objection.
Can we
wait for
The
the
rules-
to be heard on this, Judge?
Yes. Ladies and gentlemen, again, what the attorneys say is not evidence. This is an argument, and you're to rely on your own memories of what each attorney and each witness said during the course of the trial.
So what the verdict says when it gets to the part about reading the verdict, it says if you return a verdict, it should be for the highest offense which has been proven beyond a reasonable doubt. Okay, for the highest offense. Is Ronny Walker guilty of manslaughter? Yes. Is he guilty of second-degree murder? Yes. But he's also guilty of first-degree premeditated murder. Premeditated. Listen to those shots. One of those videos we put in, you can hear the shots. Listen to that first shot. Listen to the pause. That first shot was to her back. She gets out of the car, just like Robert Creed says, and then the next 5 shots are after a delay. So you have one shot, delay. And then you'll hear bang, 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 4 shots quickly in a row, delay. And then bang, one final shot. Premeditation. The fact that he drove her to the location he drove her to tells you all you need to know. But if you weren't completely convinced at that point that it's premeditation, because why else is he driving Nilexia Alexander to that spot other than to kill her and dump her body in that vacant lot? If that doesn't convince you alone, those shots and the order of those shots, no question at that point. Now, Nilexia Alexander was lured into that car by someone she knew. She was taken for a drink, something she just completely unsuspecting of what was going through the mind of Ronny Walker. Then Ronny Walker drove her to a dead-end street by a vacant lot. And he executed her there, leaving her body. You saw Ronny Walker getting out of that car on video at the Thorntons just a little while after this murder. Like nothing happened. But we know, ladies and gentlemen, what happened. You know what happened, ladies and gentlemen. This was a man on a mission, a man premeditating murder. Nilexia made poor decisions in her life. Running away was a very poor decision. And I'm going to ask you, ladies and gentlemen, please don't discount her life because of how she lived her life. She deserves the same as any other victim who's murdered. The same respect, the same thought. Don't dismiss her and say, well, she was living a dangerous life. She kind of, put herself in that spot. It's going to happen. And downplay this at all. She was 14 years old, and she got in the car with a man who she trusted. The wrong man, but a man she trusted. The evidence has shown, ladies and gentlemen, beyond a reasonable doubt that on May 6th of 2022, Ronny Walker committed first-degree murder as charged and tampered with that physical evidence afterwards. And although Nilexia Alexander made the wrong choice, I'm going to ask you again, ladies and gentlemen, make the right choice today and find the defendant guilty as charged on both counts. Thank you.
Hi, members of the jury, I want to thank you for your attention during this trial, please pay attention to the instructions I'm about to give you. Ronny Walker, the defendant in this case, has been accused of the crime of murder in the first degree and tampering with physical evidence. Ronny Walker is accused of murder in the first degree, and first degree murder includes the lesser crimes of second degree murder and manslaughter, all of which are unlawful. However, the killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find that Nilexia B. Alexander was killed by Ronny Walker, you will then consider the circumstances surrounding the killing and deciding if the killing was first degree murder or second degree murder or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. One, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or when the killing occurs by accident
I tell you, as soon as I unmute my mic, of course, the stream is going to come back up. I think I jinx it sometimes. Let's see. We into jury instructions, although they can be pretty dry, but let me know what your thoughts are. I'll be trying not to pause it in the middle of them talking, but considering that they are having issues with Channel 10 today in regards to their coverage. And I guess we had an inkling earlier that this may happen because remember, the cameraman had the camera on the seat at some point in time on the benches where we were looking at somebody's purse for a period of time earlier when we were looking at the testimony. So, and them arguing in regards to the jury instructions. So hopefully the live feed will be back here soon. And usually it was only typically glitching out for like a second or two, but this time it's a little bit longer. Let me see here. Make sure we're all the way caught up. And we're not missing anything. Nope, we're still waiting for that live feed to come back in. Hopefully soon.
a reasonable person would have lost
Okay,
normal
here we go.
self-control and would have been driven by a blind and reasonable fury. There was not a reasonable amount of time for a reasonable person to cool off. And a reasonable person would not have cooled off before committing the act to cause death. And Ronny Walker was in fact so provoked that he did not cool off before he committed the act that caused the death, of Nilexia Alexander. If you have a reason, yeah, come on up. I think it was just a double. That's the same thing.
It should say second degree murder, not first degree.
Is that what it is?
Yeah,
So,
sorry.
Yeah.
Yeah, it should say second degree murder.
I got it.
If you just want to read second degree murder.
I'll shut that
So,
in.
yeah.
Just want to make sure I get that right. I'm going to start that one over again. So what I neglected to say is to prove the crime of second degree murder, the state must prove the following three elements. One, that Nilexia Alexander is dead. Two, the death was caused by the criminal act of Ronny Walker. Three, there was an unlawful killing of Nilexia Alexander by an act eminently dangerous to another and demonstrating a deprived mind without regard to human life. An act includes a series of related actions arising from and performed by a single design or purpose. An act is eminently dangerous to another and demonstrates a depraved mind if it is an act or a series of acts that a person of ordinary judgment would know is reasonable and certain to kill or do serious bodily injury to another, and is done from ill will, hatred, spite, or evil intent, and is done of such a nature that the act itself indicates an indifference to human life. in order to convict of second-degree murder, it is not necessary for the state to prove that the defendant had the intent to cause death. An issue in this case is whether Ronny Walker did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation. And in order to prove that a reasonable person would have lost normal self-control and would have been driven by a blind, unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act to cause the death, and Ronny Walker was in fact so provoked and did not cool off before he committed the act that it caused the death of Nilexia Alexander. If you have a reasonable doubt to whether the defendant acted with a premeditated design to kill because he acted in the heat of passion and based on an adequate provocation, you should find him not guilty of second-degree murder. The defendant did not act. Let me see here. It's a repeat page. Now, the lesser included was also manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt: that Nilexia Alexander is dead, that Ronny Walker intentionally committed an act or acts that caused the death of Nilexia Alexander. Every person has the duty to act reasonably towards others. If there's a violation of that duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Tampering with physical evidence. To prove the crime of tampering with physical evidence, the state must prove the following two elements beyond a reasonable doubt. Ronny Walker knew that a criminal trial, proceeding, or investigation by a duly constituted prosecuting authority, law enforcement agency, grand jury, or legislative committee was pending or is about to be instituted. And two, Ronny Walker destroyed, concealed, or removed any record, document, or other item with the purpose to impair its availability in such proceeding or investigation. If you find the defendant guilty of tampering with physical evidence, you must further determine whether the state has proven beyond a reasonable doubt that the tampering related to a criminal trial, proceeding, or investigation related to a capital felony. The court instructs you that murder in the first degree is a capital felony. If you find that Ronny Walker committed first-degree murder, second-degree murder, or manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a firearm. A firearm is defined as follows. A firearm is a weapon which is designed to or may readily be converted to expel a projectile by the action of an explosive. A weapon is defined as any object readily capable of inflicting harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used or threatened to be used or attempted to be used or intended to be used to inflict bodily harm. If you find that Ronny Walker committed first-degree murder, second-degree murder, or manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty only of first-degree murder, second-degree murder, or manslaughter. If you find that Ronny Walker committed first-degree murder or second-degree murder, you will also be asked to determine whether the state has proven beyond a reasonable doubt that during the commission of the crime, he actually possessed a firearm and or discharged the firearm and or the discharge of the firearm caused death. To actually possess a firearm means that the defendant carried a firearm on his person or had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. The principal theory. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proves beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. To be a principal, the defendant does not have to be present when the crime is committed or attempted. For first-degree premeditated murder, or second-degree murder, or manslaughter, the state must prove the defendant intended the killing of Nilexia Alexander occur. It is not necessary for a principal to know every detail of how the first-degree premeditated murder, or second-degree murder, or manslaughter will be committed, as long as the principal intended the first-degree premeditated murder, or second-degree murder, or manslaughter to occur, and did some act or said something that was intended to help and did help the first-degree premeditated murder, or second-degree murder, or manslaughter to occur. To be found guilty of first-degree premeditated murder, or second-degree murder, or manslaughter with a firearm as a principal, it is not necessary for the state to prove the defendant knew another participant of the first-degree premeditated murder, or second-degree murder, or manslaughter would be or was armed. Mere presence or knowledge in flight. Mere presence at the scene of a crime is insufficient to find the defendant guilty of that crime. Likewise, knowledge that a crime was occurring or was about to occur is insufficient to find the defendant guilty of that crime. This remains true even if the defendant fled from the scene of the crime. If you find that the defendant was present when the crime was committed, but you are not convinced beyond a reasonable doubt that the defendant participated in the crime, you must find the defendant not guilty. If you find the defendant was aware that a crime was occurring or was about to occur, but you are not convinced beyond a reasonable doubt that he participated in the crime, then you must find the defendant not guilty. The defendant has entered a plea of not guilty. This means you must presume and or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond every reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything, as I had previously explained to you. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere doubt, a possible doubt, speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, after carefully considering and comparing and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of Ronny Walker may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some of the things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Has any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony that he or she gave in court? Has the witness been convicted of a felony or a misdemeanor involving dishonesty or false statement? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered. but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witnesses. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert opinion is only reliable when given on a subject about which you believe him or her to be an expert. Likewise, like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claimed to have helped the defendant commit a crime has been promised immunity. A witness who claims to have helped the defendant commit a crime has been promised immunity from prosecution, hopes to gain more favorable treatment in his own case, may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness said about the defendant. So when a witness of that kind may be entirely truthful when testifying, you should consider the testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or other evidence in the case does so, then you should find the defendant guilty. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusions about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside of the court has been placed before you. Such a statement should always be considered with caution and weighed with great care to make certain that it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to whether when the defendant made the statement had he been threatened in order to get him to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. There are some general, These are some general rules which apply to your discussions. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you
How many of y'all think the jurors are asleep? Like, get this over with already. Give us the instructions or read this faster so we can get back here and deliberate. Like, jury instructions can be so dry, but I know that they have to be read by the judge so they can understand them and they can have it on the record. But my, oh my, I'm surprised he hasn't had a drink of water yet. Let me know your thoughts. Guilty or not guilty? That is the question. You be the judge. Okay, guys, we're going to get through this.
fail to follow the law, your verdict will be a miscarriage of justice. There's no reason for failing to follow the law in this case. All of us are depending on you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything that I may have said or done that made you think that I preferred one verdict over the other. You may find the defendant guilty as charged in the information or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict should be not guilty. It must be not guilty. A separate crime is charged in each count of the charging document, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict form returned as to each. A finding of guilt or not guilty as to one crime must not necessarily affect your verdict as to any other crime charged. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared, and it is as follows. And you're going to have all these instructions when you go back. We, the jury, find as follows is the count one, and there are 4 letters. You will choose only one letter, A, B, C, or D, and answer all the associated questions with each letter. A, the defendant is guilty of murder in the first degree as charged, and 1, did the defendant actually and personally kill Nilexia Alexander? Check yes or no. 2, did the defendant personally carry, display, use, or threaten or attempt to use a firearm? Yes or no. Did the defendant actually possess a firearm? Yes or no. Did the defendant discharge a firearm? Yes or no. Did the discharge cause the death of the victim? Yes or no. B, the defendant is guilty of murder in the second degree, a lesser included offense. And those same 5 interrogatories. Did the defendant actually and personally kill Nilexia Alexander? Yes or no. Did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes or no. Did the defendant actually possess a firearm? Yes or no. Did the defendant discharge a firearm? Yes or no. Did the discharge cause the death of the victim? Yes or no. C, the defendant is guilty of manslaughter, a lesser included offense. There are 2 interrogatories with this choice. 1, did the defendant actually and personally kill Nilexia Alexander? Yes or no. 2, did the defendant personally carry, use, display, attempt to use, or threaten to use a firearm? Yes or no. And the final choice, D, the defendant is not guilty. We, the jury, find is the count 2. Check only one letter. There are 2 letters here, A and B, and any associated questions. So A, the defendant is guilty of tampering with physical evidence as charged, and 1 interrogatory. Was the defendant related to a criminal trial proceeding or investigation of a capital felony? Yes or no. B, the defendant is not guilty. So say we all, on whatever day your verdict comes in on, you write the date in, and there's a signature block for the 4-person of the jury to sign and print their name and return that at the appropriate time. So the first thing you're going to do, let me get the right page here. Well, in just a few minutes, you're going to be taken back to the jury room by one of the court deputies. And the first thing you should do is choose the 4-person, which I previously mentioned, who will preside over your deliberations. The 4-person should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It's the 4-person job to sign and date the verdict form when all of you have agreed on a verdict and to bring that verdict form back to the courtroom when you return. During your deliberations, jurors must communicate about this case only with one another and only when all jurors are present in the jury room. If a juror uses the restroom, the deliberation should stop until that juror returns. You're not to communicate with any person outside the jury about this case, and until you've reached a verdict, you must not talk about this case in person or through the telephone, writing, use of electronic communication such as email or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction that I've given in this case, you must tell me by giving a note to one of the court deputies. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom, and the rules do not allow you to bring those phones or devices, those electronic devices, into the jury room. So kindly leave those devices on your seats where they will be guarded by the court deputies while you deliberate. If you need to communicate with me, send a note through one of the deputies. If you voted, do not disclose the actual vote in that note. If you have a question, I'll talk to the attorneys first before I answer, so it might take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever evidence and exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. And even if you do not like the laws, they must still be applied. You must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has a right to violate the rules we all share. So, jurors number 13, 14, and 15, if you will remain seated, I'm going to send jurors 1 through 12 back into the jury room. Sure.
Okay, guys, we have our jury instructions. They have been sent back to the room. Let me turn this down a little bit. So the feed has ended. I'm gonna go ahead and stop sharing it because the jury has been sent back. So we are officially on verdict watch. Tell me, how long you think the jury gonna have this? That's what I want to know. How long will they have this case? Let me get this. So how long you think they're gonna have it? Is this quick? Do we come in on a Monday and leave on a Monday and we're done? Or are they gonna be back there deliberating for a while? Make sure that you have your notification bell on. You have subscribed. Like the video, and that way once the verdict comes in, I'll definitely go live. You know, I'm gonna bring you straight into the courtroom in order for everybody to see it, so we can definitely determine what the jury, well, definitely see what the jury has decided in regards to Mr. Ronny Walker. Allegedly he's on trial for the murder of Nilexia Alexander, a young 14-year-old girl. We have a community that's completely in shock how heinous this was. And I mean, it just appears that, you know, not to say any murder is for, you know, has a good reason, but this really seems very senseless. Like he just was tracking her down, following her, lured her into his car. Unfortunately, she was running away from home due to some issues at home. Well, I think with her biological mom, which caused her to be acting out. But so I'm not sure exactly why she got in a car. I guess it appeared that she knew him, but unfortunately, a young life was taken at the end of the day, and now will justice be served? I definitely want you guys to put your comments in regards to guilty or not guilty. Hit your like, subscribe, and your notification bell, because as soon as the verdict is in, I don't know if it's going to be 5 minutes from now. Well, I know it won't be 5 minutes from now, right? Considering that they just went back there. They got to at least get some kind of sit down and pick their foreperson. But as soon as the verdict comes in, we right back in there in regards to determining if the jury decides if he's going to be guilty or not guilty in regards to this case. I appreciate everybody hanging out with me today. And viewing the trial with me. And we'll be back as soon as a verdict comes in. Once again, this is Take It to Trial, where we bring the courtroom directly to you, and you can be the judge. Bye, guys.